Excellent. Well, good morning, everyone. Good morning. On first housekeeping matters in terms of today, we don't have a schedule through till lunch. It might take a bit longer, but we'll try to, if we can decide whether we want to take a late lunch and finish or see how we're going. Mr. Prebbleton has advised that the reserves manager may be available, but not till 12:30 to tell me a little bit more about the broader reasoning, planning, function, location choice of the reserve, which I do see as quite significant. And so I will look to take advantage of that, which would be helpful. Phones off, everything else, I think. Is there anything from your point of view that you want to do before we start today?
I don't think so, sir. We have had Stormwater and Ndrs next week. We've had a discussion with one of the submitters yesterday afternoon. I think that will just be a matter of waiting until they've delivered their presentation, and if there's any follow-up issues that you would like addressed, then I can certainly attend to those.
Yeah, that's fine. Well, I certainly did take a site visit yesterday, and that particular area, interface there with the German's property and Hampton's Road, was particularly helpful, I think, in getting a bit of a feel of that. So that's good. All right. Well, and first submitter today is Mr. Putra, who is on Zoom. Good morning.
Good morning, Commissioner. Can you hear me okay?
Yes, I can.
Okay. I can't hear you that well. I did hear you say my name, but so we'll see how we go with questions. But if we have trouble, perhaps we could put them in a chat or an email to me if I can't hear you properly.
Can you hear me more clearly now?
Yes, it's not perfect, but I can hear you a little bit better now.
I'll bear that in mind and try and speak very clearly.
Great, appreciate it.
I've read your evidence. Would you like to kind of summarize where you are at? I don't know whether you've got anything else you want to present.
Yes, thank you. So I will just quickly talk through my key point and also just respond to some of the issues raised by Ms. Aston yesterday. So I did listen in yesterday and heard a lot about how this plan change area will accommodate a growing population and provide for well-functioning urban environments, which is of course an overarching objective of the NPSUD. As part of that well-functioning urban environment, there's also a requirement under the NPSUD for Tier 1 authorities, which includes the Selwyn District Council, to be satisfied that additional infrastructure to service development is likely to be available. And that additional infrastructure, by definition in the NPSUD, includes schools. In this case, the ministry has assessed that there's an expectation that there'll be an increase in people, and that might trigger a need for a new school. And in the long term, the existing school network within the Prebbleton area and the wider catchment is unlikely to have enough capacity to accommodate all that growth going on. So kind of in short, the required infrastructure to service the growth isn't necessarily there in terms of educational facilities. I think it's important to show to the wider community that the ministry is considering this growth and considering capacity within schools, and it's been raised by a number of submitters who have stated their concern about capacity within the existing school network and what that will do. So the ODP provisions really do provide an opportunity to sort of signal the intent and provide an enabling framework for educational facilities. Ms. Aston also states in her evidence that there's already support for educational facilities within the ODP by having supportive provisions for community facilities. As I've stated, though, that in my evidence, community facilities are not incorporated by or don't incorporate educational facilities in schools. They're both defined separately in the Selwyn District Plan. And I think therefore it's appropriate to sort of provide for them as separate uses as well. So I acknowledged yesterday in her statement, Ms. Aston said that she disagrees with these definitions and she prefers the Oxford Dictionary definition for community facilities. I think that we do need to rely on the district plan provisions and the definitions where there is one provided though, and that's the case here. So in her primary evidence, Ms. Aston recommended an update to the narrative of the ODP and recommended that consultation with the Ministry of Education should occur prior to subdivision. I support this variation and think that this requirement should be further sort of embedded in the district plan. And I've made some recommendations in my evidence about where that would fit. So chapters 12, which is subdivision, and 4, which relates to the objectives and policies of growth in towns. And basically what that does is just put a bit more weight behind that statement. This approach, or the enabling provisions approach, is one that the Ministry of Education is encouraging throughout the country, including other plan changes without the projected outside the projected infrastructure boundary in Selwyn, but also nationally where we're seeing a lot of growth that's unplanned or ahead of sequence. Just to clarify a point that Ms. Aston made yesterday regarding my evidence, in paragraph 4.11, I said that this approach of enabling for educational facilities was agreed with the applicants of plan changes, the proponents of plan changes 69 and 73. And by referencing those plan changes, I'm really just comparing the approach for providing for school infrastructure of these areas where there's growth, where there wasn't any expected. Not trying to draw any conclusions around the scale or ultimate land use, look or feel of those precincts. Finally, just on Ms. Aston's comments yesterday regarding traffic assessments, where she stated that I'm seeking an assessment of possible effects caused by a potential future educational facility within the plan change area. Just want to clarify that's not something I'm seeking. In the ministry submission, there was some concern raised by Prebbleton School around what the potential traffic effects might be on them. They have done some further analysis, however, and don't require any additional relief. So overall, substantial growth is envisaged within this area that wasn't previously planned as a result of it being outside the projected infrastructure boundary. There's potentially going to be a need for a new school, and the ODP provisions through this plan change can be used to signal that requirement. Doing this would support the directives of the regional policy statement, which provides some guidance in terms of ODP processes, which include consideration for schools, but also the MPS in terms of providing the additional infrastructure to service growth. That's kind of all I have to say. So really, there's the one issue really, just in relation to enabling those provisions.
So the Ministry of Education, through its advisors, gets road growth forecasting and looks at the dynamics of growth in areas and needs. We've obviously got a primary school in Prebbleton. What is the capacity? What if you like? What is the capacity? If you like, the capacity, and I've probably got a growing population there at the moment because some not all the, heard yesterday, not all the sections while they've all been sold are yet, if you like, built and occupied. So you've got a growth situation as we speak. What is the room, the headroom in terms of site capacity for the existing school?
I don't actually have the insight into how many more students the school can accommodate. I just take guidance from the ministry saying, you know, that there is going to be a need for a new school here in the future, and can we make sure that there's going to be enabling provisions in the district plan for that? And yeah.
So that's irrespective of these plan changes, or this is one of 3 private plan changes being considered. We're only looking at that one. It's the concern, if you like, the cumulative effects of those 3, or are you saying that this particular plan change 72 could, in yours or the ministry's understanding, trigger the need for an additional school?
So the way that the ministry has planned for their network within the Greater Christchurch area is by sort of working on a assumption that development would occur within the projected infrastructure boundary. And now that we are seeing a lot of growth occurring, or plan changes being lodged that are outside that projected infrastructure boundary, it makes the planning for future schools increasingly difficult. And as a result, the solution is to provide for a more enabling planning framework within all those areas. So in all the areas outside the projected infrastructure boundary, the ministry is really encouraging that provisions are in place for a potential new school. So we have worked with directly with some of the developers to get these very same provisions into the plan change documentation. And yet, I mean, this would be a consistent approach for others that we're seeing.
I sort of get that. I've got a few questions about that, but the justification for that in this particular plan change logically must be that you consider the area of land as potentially suitable location and potentially suitable characteristics for a future school. Is that correct?
Yes, my understanding is that is correct.
Okay. In terms of enabling provisions, clearly the ministry designates new school sites. It has that power through the legislation. So do you really need more enabling provisions than that, or are you what you're really looking for is a vehicle to be able to monitor and hook into specific growth proposals to be able to judge when you should move? Timing is everything on these things, and obviously you need to get in early in terms of securing land. Is that more the enabling outcome that you're looking for, which the consultation that you've agreed with the proponent would clearly facilitate?
I suppose there's a couple of points on that. Yes, normally the Ministry of Education does use the notice of requirement process to designate sites. Firstly, when territorial authorities assess those notices of requirement, they do also have to have regard to the relevant provisions of the district plans, and therefore having a supportive and enabling framework in place is always going to be more helpful. Secondly, not all educational facilities are provided by the Ministry of Education and can be designated, so that would include private and special character schools, which can also contribute to meeting the demand for educational facilities. And then finally, I suppose it is much easier to deal with lots sizes and layouts at the subdivision stage rather than later down the track when you're sort of dealing with sites that potentially need to be amalgamated. So in our view, or in my view, this is the right stage to be getting those provisions in there.
All right, that's very helpful. Thank you very much indeed. Appreciate your time. Thanks very much.
Thank you.
Right. 5 minutes early for City Council and Regional Council. They're appearing via Zoom also.
I just need to turn the camera and microphone on.
In the waiting queue.
Mm-hmm.
Okay, we've got Mike Wakefield. Yes, we can. Good morning, Mr. Wakefield.
Good morning, Commissioner. Can you hear me okay here?
Can you hear me?
Yes, I can. It is a little bit muffled at this end when you're watching on the Zoom link. So if you could speak close to the microphone, that would help, I think.
I can get very much closer.
I can see that. It is, for some reason, there's a bit of disturbance in the background. And I noticed that on the YouTube link yesterday, it was quite hard to understand some of the questions and responses.
That was intentional, so you couldn't get through what was going on.
Oh, well, if that's the case, I accept my place in this hearing and I'll happily continue. We're just waiting for Mr. Langman. I think he's just joined the call. So once he's on, we can make a start, even if it's 1 or 2 minutes early.
No, that's fine. Let's just wait till Mr. Langman is actually on board. And in the meantime, I should just organise myself.
Has just popped through.
Oh, grab it.
If you would like to.
Yes, no, let's take that opportunity to see some meetings. I understand the rest of the morning. Thank you. Mr. Wakefield, we'll just put you and Mr. Langman on hold for a couple of minutes while we talk.
Oh, sorry, can you repeat that for me?
Put you on hold a minute. I see Mr. Langman is on board, but we're just going to put you on hold for a few minutes while we grab a council advisor in the parks area to just fill me in a little bit on the bigger picture planning for Birches Road Park.
Sure thing. Thank you.
Quite hard. Can you just remind me your name again?
Mark Rikers.
Mark Rikers. Yeah, thank you, Mr. Rikers. So I'm interested in the history of the development of the park decision. That would obviously feed into reserve strategy thinking as well as plugging into LTP financial provision. And how that relates, I suppose, to Selwyn's bigger picture thinking on related growth and provision of facilities. I'm conscious that Lincoln has pretty good facilities. Wollaston, I'm not so familiar with, but the decision to go to Prebbleton, I see as a particularly significant one in strategic terms, rather than just the local, as well as the local circumstance of this particular proposal. I'm really keen to understand a little bit more of the strategic thinking around that decision and how it relates, if you like, to wider growth thinking and services provision.
Yes, so in 2015 we prepared a open-based strategy for the council, and this was to provide a framework for the provision, acquisition, and development of open space recreation for the district at the time. As part of that, we identified areas around the district that would require additional land particularly for sports park use and for other nature areas and development of passive recreation spaces as well. So we embark on a program of land acquisition well in advance of development, identifying sites that would meet adopted standards and provisions. So we have for sports park, we adopted a standard of 3 hectares per 1,000 population as a guideline. That's based on the New Zealand Recreation Association standards, which is a national standard. That's right at the high end. 3 hectares per 1,000 is right at the high end of that. And we chose the high end because of the growth and district, and particularly the proportion of younger people more likely to participate in active sports and recreation. So in terms of that, we purchased the 22 block of virtual road facilities that was part of our overall strategy. And that was identified as a sports park and nature hazard areas, walking spaces and those sort of things as well. And we also purchased 100 hectare block in Rollston, which is on the Griffith Rollston, on Williams Road, Levi Road, and that's also been set aside for sport recreation and going forward to the population growth. In addition to that, we're also in the process of acquiring some land in Lincoln. And there's an additional extension to the existing domain. So we've actually been trying to acquire that land for quite some time and provide a sort of contiguous link of green space from the existing domain right through the boundary road and the joint Lincoln High School. We hope to get that pretty much nailed by the end of this financial year. And we've also bought land in an extension to Broadfield Reserve, which is also within that overall catchment of Lincoln Creek. That's the last area as well. So, and that's all been part of this strategy that we developed some time ago. We've had to bring a lot of the development forward just because of the growth. So, for instance, Foster Park, which we bought in 2010, in Rollston, 32 hectares of total there. So that was going to be developed originally over 15 years ago, to be developed in approximately 7 to 8 years, basically completed that to meet sport and recreation needs. So the one in Prebbleton, in Virtue Road, that's servicing a catchment in sort of Prebbleton and Lincoln area mostly, a bit of Lincoln, but also Prebbleton. And the existing domain, the Prebbleton domain, has been over capacity for some time. So it will provide additional space there for active sports and for recreation purposes. We're developing the third stage of that at the moment. And we actually brought the second minor stage of that forward just because of growth. And it's likely when we review the long-term plan, we'll bring the final stage forward for that as well to keep pace with growth in the area. And it is a set of servicing a bigger catchment than just Prebbleton as well. And Prebbleton is also a bit of a funny one, and there is a bit of a suction effect towards the city with some recreation activities, and people do tend to use some of the spaces that are important for them and for the spaces as well.
That's very helpful, thank you very much. So in terms of it's been designed around serving Prebbleton, but also Lincoln ahead of the expansion of Lincoln, or how does that sort of fit with what you're doing at Lincoln, the extension for the existing domain there? Is it, if you like, those two together, added together, sort of meet the demand, or is there a timing thing there that you're going faster at Prebbleton, so you can go slower at Lincoln?
Yeah, so it was mainly around the fact that we take some time to get the acquisition across the line at Lincoln. So to meet demand, we've actually pushed it with Prebbleton development. Although that's in part because of the existing capacity issues that Prebbleton made. But the new park in Birches Road is actually quite convenient for people who Lincoln to use as well, because it's on the rail trail, so it's like on the bus route, so it's really easily accessed. With the land in Lincoln, we may well bring that forward a little bit as well when we actually acquire it, because we've got demand issues in Lincoln as well in terms of the existing space.
It's all on, isn't it?
It's all on. Yeah.
That's really, really interesting to see the whole picture, so thank you. On a more local note, the northern edge, we have for part of the Drinnan's land, 2.2 hectares of their rectangle that sits between your northern boundary and Hampton's Road. A submission saying that should be included within Plan Change 72 and only compared to residential development. How from a design sense and interface sense, how do you see that sort of northern edge?
Yeah, so it's sort of from a sort of surveillance and having people around the edge of the park is actually a good thing, rather than having just open space. Because looking at the very site starts to get used, people there, and having some sort of on-site surveillance up there is quite a good thing. Also, it provides that solid connection with the actual residential interface, so it does have that aspect to it. We did actually think about vegetable land, the block that just goes straight on Hampton Road at one point. So we have actually thought about that, creating a larger edge to the park outside, although with that park it does actually have very good frontages anyway. It's got two significant road frontages and a partial road frontage on Hampton Road. So it's not almost going to be blocked away and behind all the houses.
Yes. Yes. So if there was residential frontage there, you would want it to be addressing the park, if you like, not just kind of off an 8-metre fence and then back up backyard. Is that right?
Yeah, very much so. We do have one of our policies related to Mr. Hatch with open fencing around our open space areas. So we do that with interface with it rather than having it blocked off. We could also there's connections that cut in Plan Change 72 that come through there that we could create another walking connection in between those blocks that directly links with the green spaces proposed in Plan Change 72.
That was going to be my next question in terms of, yes, I think Ms. Lowenstein has suggested if that was to be included, there should be two cycle walking type connections through, and you're aware of that. So that's all there. Excellent. Thank you very much for your time. I appreciate it. Okay. Thank you for bearing with us. It's been a little bit more than 5 minutes. We have Mike Wakefield still on Zoom. Yes, we do. He's just triggered back in. Thank you very much. Joint submissions and evidence for Christchurch City Council and Canterbury Regional Council. Clearly, I've read them. more than once. Over to you for a summary and obviously perhaps reaction to what you managed hopefully to hear yesterday in terms of there was clearly some rebuttal of some of the planning evidence from Ms. Aston, and I hope that will have been up on the website as well, I think, if you weren't able to hear it clearly. So I'm hoping, I appreciate it hasn't been very long, but I'm hoping you've had a chance to at least consider that. So over to you.
Look, thank you very much. Look, we have had the opportunity to listen into some of the hearing, and Mr. Langman has read the summaries which were uploaded overnight. I'm not going to say I heard and captured all of the conversation because the Zoom link has been a little bit trying, but we've done our best to focus in on the key issues at issue between the parties, and we'll provide a summary at the outset before having hopefully some discussion with yourself today. Mr. Langman has prepared a separate summary which he will be able to read too. I haven't done the same for legal submissions on the basis that I understood you had pre-read everything coming into this process. So moving on, the City Council and the Regional Council and the legal submissions at least have focused on three issues. The first being the role of the statutory framework, bearing in mind that this is a statutory decision that needs to be made on this request. The submissions focus on the NPSUD, which is obviously one of the key points here at issue between the parties, the role of that document and indeed the approach to interpreting and applying it alongside the CRPS. And then the final point which the submissions address is the merits of this particular proposal, bearing in mind that the merits assessment is largely a planning piece of work. Mr. Langman has of course focused on that in his evidence, which you would have read, and he'll be able to address those merits points today as well. Now, I thought the best approach here is to just provide a bit of a summary that tries to pick up and respond to some of the comments made by the applicant so far. And if you do have any questions along the way, then feel free, of course, to interrupt me and put those to me. The statutory framework is agreed. Everyone understands the colonial vineyards tests apply. It sets out the various aspects that need to be informed by or need to be assessed as part of informing your decision here. I'm not going to dwell on that at all, but what's at issue between the parties is that there are two different documents which are interpreted differently by the two parties here. The NPSUD on the one hand and the regional policy statement on the other. You would have heard from my friend yesterday that this issue is not new or not unique to this hearing. There have been a number of private plan change hearings that Selwyn have accepted for processing up to now. And there's been one decision issued so far which has some cursory relevance, although the factual scenario was different. But in terms of this case here, where the land is all outside the GPAs and the FTAs shown in the CRPS, there are a number of plan changes still awaiting decision with a different commissioner. But in addition to that, similar issues have also been raised through the Selwyn District Plan review process, where the legal arguments have been canvassed, as well as the interpretation issue between this party, councils, and the other parties involved in those processes. Now, I'm not suggesting that you would have, or anticipating that you would have read all of that material, but of course it is all available online if you had the motivation for some late night reading. There's quite a volume of material to do with this particular interpretation point. Look, moving on, the NPSUD for these councils is not interpreted as being the enabling document that it's being pitched as being by the applicant. The applicant submissions do say that it's an enabling document and they rely on that to support their particular request in this case. What our response to that is that this document forms part of the government's urban growth agenda, which also has as one of its mainstays creating well-functioning environments and reducing any unnecessary urban sprawl. The NPSUD is limited to urban development matters only. It is distinguishable from the CRPS on that basis because it doesn't try to capture all of the relevant RMA issues that need to be addressed when dealing with requests on these lines. The CRPS provides that multifaceted document that gives the policy direction across the board that must inform any decision. So the NPSUD is focused on this one issue. And when reading it as a whole, the council's interpretation, and I mean City Council and Regional Council, is that it is focused on enabling, yes, but where you've got the existing urban environments already mapped, where that development is enabled. The NPS focuses on intensifying within those areas. And you see that quite clearly within your city centre and your metropolitan urban zones. But also the overall direction is to intensify where it's already there and provide for it in limited circumstances elsewhere, which is where we get to this policy age responsive requirement. It's not able to be interpreted at face value as enabling or providing this innate flexibility that other parties are suggesting it has. The other aspect to the NPSUD, which these councils consider to be relevant, is that there is a very clear focus on well-informed decision-making processes by local authorities. You'll see that through the requirements that are put on local authorities to gather information, undertake all sorts of monitoring, and then respond to that monitoring data in various ways to ensure that they're providing sufficient development capacity to service anticipated population growth. These decisions are all expected to be made on a collaborative basis, and Policy 10 is relevant on that point, sir, by requiring that councils collaborate as part of implementing the NPSUD. They don't operate as a standalone, and they're not expected to operate on a standalone. There might be cases where various councils are required to make decisions, but Policy 8 does anticipate collaboration in giving effect. I see you're reaching for the NPSUD there, sir, and if you need to find some time to consider that language, then feel free to let me know.
Is it policy 8 that you're referring to in terms of collaboration?
Policy 10. Policy 10.
Policy 10, sure, yes. Work together when implementing, yes.
And if you go through those remaining limbs, so Policy A is more about the local authorities that share jurisdiction, but then it also creates other obligations. You engage with providers of development infrastructure and then engage with the development sector to identify significant opportunities for urban development. But that policy direction is quite clear. It's not saying that the NPS needs to be implemented on a one-off basis or separately by various district councils. In this case, you've got 4 councils, all of which share jurisdiction over the Greater Christchurch urban area. And that policy does encourage and anticipate collaboration. The fact that clause 10B also directs engagement with providers of development infrastructure is relevant too when you come back to Objective 6 in the NPSUD. And I'll let you turn to that one now.
Yes.
Objective 6 there is framed as referencing local authority decisions on urban development that affect urban environments. And it sets out 3 objectives. Those decisions need to be integrated with infrastructure planning and funding. And that links into that policy 10B requirement that local authorities that share jurisdiction collaborate and engage with the developers of such infrastructure. They then need to be in clause B strategic over the medium term and long term. And then clause C is one that has been addressed in submissions. Those local authority decisions are also to be responsive. Now, our interpretation of that Objective 6C limb is that the requirement to be responsive actually applies at all times. And that's consistent with the way the NPS encourages and requires monitoring and data gathering. Because if that data and monitor does warrant a response, then that's what Objective 6 is all about. But Objective 6C goes on. It says responsive, comma. And the next clause there is particularly in relation to proposals that would supply significant development capacity. So you've got a distinction created there within Objective 6 between any local authority decision, where the expectation is that you're responsive as part of making that decision, but you've then got this elevated importance given to proposals that would supply significant development capacity. And that's really what we're arguing about here, because this applicant has pitched their proposal as delivering additional significant development capacity, which warrants being considered under the Policy 8 responsive planning framework.
That's qualified by particular.
That's right. It's not a substantive direction or a final answer. It's a qualified direction, and that's why one of the points you discussed yesterday with I think Council for the applicant was that there was this disagreement that Policy 8 in this responsive planning pathway is in fact an administrative pathway versus a substantive direction. The council's view, these council's view, is that Policy 8 does not direct any outcome at all. It requires councils to consider and be responsive to plan changes, but there's no substantive direction in there. And on that point, in my submission, it would be inappropriate for there to be a substantive direction to approve a plan change just on the basis that it's delivering significant anticipated development capacity. The reason for that is that this NPS, as we've talked about, is focused on urban development. It's focused on one aspect that fits within this wider statutory framework. It doesn't capture the field. The NPS-UD makes no attempts to cover the multitude of RMA issues that might be relevant. And so it's a pathway, but it doesn't provide the final answer. Our final answer needs to be reached on a full merits assessment, which is what the statutory framework in this case requires. Now, the next point I thought I would touch on is that you'll be familiar now, Policy 8 does rely on these criteria. Clause 3.8 then also references the need for regional policy statements to include criteria in their, well, regional councils, sorry, to include criteria in their RPSs. And we all know that those criteria are not yet in the RPS. As much as there's been criticism of the regional council in this case and others as to the current lack of criteria in the RPS, I'll just make a note that no other RPS yet in the country, to my understanding, has in fact included such criteria. So we're all living in this situation, I suppose, where we've got these plan change requests. We don't have any clear or confirmed criteria yet in an RPS that can provide the guidance. And so we're sort of muddling through as best we can. The difference between the parties in this case is that one is saying, that's fine, just press on because we're providing what is significant development capacity. And then you've got the regional council and the city council saying, hang on, let's be more conservative here. Let's be very careful about this decision because we haven't yet got the tested criteria in the RPS that are going to provide that sub-regional and regional guidance as to what's significant or not. And one of the points that I've had to discuss with the District Plan Review Panel, Commissioner, is the role and the positioning of these criteria and what the NPS does require of them. And it's submitted to be relevant in my point, sir, that the NPS-UD requires these criteria to be included in the regional policy statement. Now, we can't anticipate yet what these criteria will say in terms of the frame of reference for what's significant or what other criteria might be included. But the location of those is important because they are RPS criteria, which means they can't be proposed to be changed through any private plan change to a district plan. They are there and in control of the regional council, which in my submission suggests that they will need to have this wider regional focus to them rather than potentially framing significance against smaller little pockets within an urban environment. I'll just make that point, sir, because it's a matter that was being usefully discussed with the District Plan Review Panel. Now, the interpretation point, you had a discussion yesterday around this issue, and I'll note my friend's submissions at paragraph 28 will be the relevant place to start.
28.
Right.
Thank you.
Now, look, you might not be familiar, but there have been a couple of approaches to try and reconcile this apparent tension between the MPSUD and the regional policy statement. One is to adopt this approach, which is trying to read it down or read down the word avoid in the RPS so that it doesn't act as a fishhook or roadblock for any proposals. The other, which I don't understand this applicant to be pushing for, is that invoking the doctrine of implied repeal. Have you had any discussion or seen any documentation around that at all?
No, tell me a little more about
Right, so the doctrine of implied repeal is a legal construct which says where you've got two statutory provisions which can't run together, then one needs to fall away. And the way in which that doctrine works is that it's generally the later in time provision which supersedes and takes precedence over the earlier one. Now, there have been arguments made by other legal counsel that that doctrine should be invoked here, which would effectively mean that the CRPS with its avoid objective would fall away, and you'd then have the NPSUD as the relevant policy that would provide the direction, and that's in the void of that objective. Now, our submissions on that is that there is no place for the doctrine of implied repeal to be evoked, because when you actually look at what these two provisions are trying to do, it's quite clear that they're doing different things. Objective 6.2.1 is providing policy direction on various aspects associated with the growth of urban areas within the Greater Christchurch area. So it provides some substantive direction through various policy limbs that are relevant when you're determining what growth is appropriate. Policy 8 is doing something different. It provides a pathway and it provides a requirement that local authorities are to be responsive. But other than that, it relies on criteria that don't engage with the various other issues in Objective 6.2.1. So we say that when read at face value, those provisions are doing two different things. And one shouldn't fall away as a necessity when there's this apparent tension. What you should be doing is reading them together to determine whether or not there is a way to reconcile them in accordance with normal statutory interpretation. So that's the implied repeal argument. But in this case here, they're not invoking implied repeal. The suggestion is that Chapter 6 and the avoid objective should be read down, because in this case, it's effectively preempting any substantive assessment of an application. Well, on that first point, in my submission, I disagree that it's preempting any substantive assessment. What Selwyn District Council has done in this case is it's accepted this private plan change request for processing. And what we're here to do is in fact have that substantive assessment. What we say though is that irrespective of where your substantive assessment ends up, Chapter 6 of the RPS creates a quandary for you as a decision maker. Because even if you were to say, find that on the merits, this proposal satisfies the various other directions in the RPS and the MPSUD, you're not in a position to be able to issue a decision which would result in the Selwyn District Plan being non-compliant with the RPS. Section 75 requires you to give effect to an RPS, which creates that problem for you as the decision maker.
So do you accept that the policy 621 is not, there is no need for the region to review that policy in light of the NPSUD? Is that your position?
Sorry, can you just repeat that?
Is your position that the regional council does not need to review policy 621 in the RPS as a result of the NPSUD?
I'm not saying that there's no need, but what I'm saying is that we are not satisfied that there is no place for hard edges in regional policy statements or any other planning document as a consequence of the MPSUD. Whether there is a place for those hard edges is going to be a case for the merits argument.
Which seems to me in conflict. The MFE guidance is just guidance. It's not enshrined in how you apply the NPSUD, but that approach would seem to be in conflict with the MFE guidance on applying the NPSUD or that part of it.
Look, I accept that the guidance does make some high-level observations around the sorts of planning outcomes that might result, but the MFE guidance, by its very nature, and in fact the NPS itself, is a high-level document that applies across the whole country. It doesn't have that sub-regional or regional lens to it, which you expect to see through the regional policy statement and the other district plans that are required to give effect to it. So that's the problem with the guidance. The guidance has no legal weight in terms of providing any firm or strict interpretation weighting. It makes high-level comments, which various parties are obviously latching onto. But there are bits and pieces in this guidance that work both ways. And even jumping to paragraph 29 of my friend's submissions, I'll point out an example for you here. So they've underlined. They've underlined two excerpts in that second paragraph, but if you go to the preceding sentence, you've got their local authorities may choose to identify in RME plans and future development strategies where they intend development to occur and urban services and infrastructure to be provided. Well, that's all fine. That's consistent with Objective 6, Limbs A and B, where the requirement is for local authorities to be strategic and integrated. You then go on, the identified areas must give effect to the responsive planning policies in the NPSUD and therefore should not represent an immovable line. Well, there's two different concepts going on there. The first is an immovable line, which this guidance would suggest is not consistent with the responsive planning policies. But the first clause there, the identified areas must give effect to the responsive planning policies, doesn't make sense when you read that at face value. The responsive planning policies are all about unanticipated and unplanned and unanticipated development. So that if the suggestion is that you need to identify areas where those responsive planning policies apply, well, that's the situation we've got already through the future development areas. Those areas are anticipated for growth, and that's where the responsive planning policies can apply because you can bring them forward. You're not live zoned at present. Through the district plan review or other private plan changes, that's when you will be able to live zone them and then enable the residential and urban growth within those locations. So the guidance is saying a little bit of both. And then in the second sentence, it goes on, council policies, including those in regional policy statements related to out of sequence development, will need to be reviewed and, in some cases, amended. In some cases doesn't mean in all cases. It says that there is still a substantive decision to be made as to whether or not the existing RPS policies are appropriate or not. And that's where the sub-regional context becomes relevant in terms of applying and implementing the NPS. But what I'm really trying to highlight there, sir, is that the guidance is the guidance, but the NPS itself is the policy document which you're required to interpret and apply through this process. And it forms part of the statutory framework, and you've got two documents which this district plan is required to give effect to. The legal submissions do draw on that at length, and so does Mr. Langman in his evidence. Now, the final point which was discussed yesterday was this concern around the CRPS not giving effect to the NPSUD in full. And look, we've talked about this, and we accept that at the moment there is no criteria, but there is also no firm direction to include those criteria by any specific time. The requirement is as soon as practicable. And Mr. Langman's evidence has drawn your attention to the fact that the work is underway at the moment on the CRPS review. But that doesn't mean, of course, that there might not be a bespoke change to the CRPS to bring in criteria at some point between now and then. But in terms of the suggestion by my friends that the CRPS doesn't give effect to the responsive planning policies now, the observation needs to be made, well, what would be required in their view to give effect to those policies? If the suggestion is that the only way to give effect to them is to provide absolute flexibility for urban growth. The NPS doesn't say that. It doesn't say there should always be opportunities for greenfield expansion. And if it did, that would in fact conflict with some of the other higher level direction coming out of government through the urban growth agenda, plus also the enabling housing supply legislation, which is more focused on trying to consolidate and intensify your existing urban areas and avoid that expansion into greenfield rural areas. So look,
the NPSGP anticipates that all those private changes might be about greenfield development. They might not. They might be about intensification.
sorry, I missed that last point. It's quite muffled.
Prior to the recent legislative change, it's not. The policy 8 is about responsiveness. It doesn't the other provision I'm really referring to. That's specific about plan changes, but it's necessary to assume that all plan changes that would come through would be about greenfield development, although I suppose in the current settlement context they are.
Well, yes, that's right. This policy is not going to be engaged with only residential growth. Is that the question you're saying? It's all sorts of plan changes. The requirements to be responsive and the references to development capacity. It's not necessarily for housing. That's right.
Might it be about intensification?
Absolutely. Absolutely, it might say, look, we want to do a plan change because we've got an existing low density suburban zone and we want to change that to a medium or high density. And the consequence of that is we are going to be delivering significant additional housing capacity. And that's precisely what this NPS is trying to achieve. So long as it's also delivering on the requirement to be a well-functioning urban environment and satisfying whatever criteria would need to be balanced and considered through that merits assessment, then absolutely, there's the ability to be responsive in brownfield areas that are already zoned for development.
Yes. But your suggestion is that in the evidence and the submissions is that granting this would undermine the existing sort of strategic framework. In this particular case, rather than in other cases, but that's a key plank of your position, isn't it?
Yes, it is, but it's not just limited to this specific case. If your decision was to accept that you could soften Objective 6.2.1 and then use Policy 8 of the NPS as a pathway to effectively jump that direction or skip around that avoid framework, then you're undermining the role of Chapter 6 and indeed the GPAs and the FDAs. Those GPAs and FDAs were identified to satisfy the requirement to provide sufficient development capacity. So you're then saying that, look, despite that direction, you're fine to let it happen elsewhere. And if this decision was made on this case, then there'd be no principled legal basis in my submission to adopt a different interpretation elsewhere. And this is a point that we've had to discuss with the other commissioners hearing some of these other plan change requests. I don't like the phrase death by 1,000 cuts, but as soon as you decide that one can navigate its way around that CRPS avoid framework, then there's a pathway for all of them. And you're creating a quandary there because
the role of point very strongly that we need to look at the NPSGP as a whole and also Chapter 6 as a whole.
Correct.
And not just pick out bits. I mean, I'm conscious. Chapter 6. I have pulled out Chapter 6 as amended by Plan Change 1 in order to refresh my memory as to how all the elements work. And doing so, I was reminded of a policy that I don't think has been mentioned in any evidence or submission or 42A report, which is why I'm taking the opportunity to raise it now as a question more than a statement, and that is under 622, urban form and settlement, which talks in the introduction about avoiding unplanned expansion of urban areas as the precursor, and then by, and there's 5 points. Now, one of those 5 points is encouraging sustainable and self-sufficient growth of the towns of Rangiora, Kaiapoi, Woodend, Lincoln, Rolleston, and Prebbleton, and consolidation of the existing settlement of West Melton. So it is saying avoid unplanned expansion by encouraging sustainable and self-sufficient growth of towns. And I suppose in looking back at that, sort of thought about that quite hard overnight in looking at this, and thought I should bring it to the Chief's attention, because I'd like some comment on that, on the dynamics of that policy, to assist me from anyone as they go through, including the proponent and the client and the council. I think, but I'm not sure, is that it might be the actual only policy that actually specifies Prebbleton individually, but I may be wrong there may be others. But it seemed to be, in terms of reading section 6 as a whole, it's one that should not be forgotten. And that may be a question more from Mr. Langman than legal sufficient, but I'm raising it so I don't forget it.
It is addressed in Appendix 13 of the application material.
Appendix 13, yes, I haven't been back to it. I went back to a few appendices last night, but not all of them. Thank you. So I'll just sort of welcome comment on that in the context of your submission.
No, thank you for that. I suspect you're probably right. It's more of a planning discussion that Mr. Langman may be able to assist you with, but I do think that is from my understanding, it is the only specific reference to Rolleston in Chapter 6. I'll move on from that point. The final 2 points that we've addressed in legal submissions and also in Mr. Langman's evidence relate to whether or not this particular proposal constitutes significant additional development capacity. And without cutting across Mr. Langman's evidence at all, I just thought I'd make the observation that the significant additional development capacity must mean something. Because what we are talking about here is unanticipated development. If this particular policy pathway was able to be relied on in cases varying from 100 lots right the way through to 3,000, and adopts and approach it through various lenses in terms of significant against Rolleston or significant against Prebbleton or Selwyn or Greater Christchurch, there's very little certainty in terms of how you actually determine what is significant or not to warrant being brought forward in this way. And I note that the various plan changes that are on foot at the moment within Selwyn, outside of the FDAs and the GPAs, collectively add up to approximately 8,000 additional dwellings. And when you look at that total figure against the medium-term housing needs of Selwyn, the consequence of granting these would effectively double the supply across that medium term. So we're not talking about a few applications and a few lots here and there. We're talking about doubling the housing supply for Selwyn, which is a huge consequence for infrastructure provision, roading, wastewater, and all of those other aspects. And indeed, the other point to note is that enabling all of this additional development and applying it with residential zones would, in my submission, create a potential undermining of the attempts to intensify your existing urban areas. So the direction in the NPS is to focus where you've already got it and make it more efficient. And if you're allowing this greenfield expansion to occur, you're making it incredibly difficult to try and encourage people to move back and create that consolidated and compact urban form. And then you throw into the mix the enabling housing supply legislation as well, which is of course going to be upscaling the capacity anyway through the medium density residential IPIs that are going to come along. So there's a few moving parts here that need to be brought to your attention because they are relevant to what's going on in this district.
Yeah, there's a lot of moving parts right now, and it makes it quite challenging, but yes, certainly I'm well aware of them. Yes, carry on.
Now, the final point we addressed in submissions, which I don't feel I need to take you through because you have already read them, is just highlighting in the conclusion that there is a statutory decision to be made here. At the moment, we do have an NPS, which is expressed in, as you'd expect, more abstract terms, and Policy 8, which doesn't contain any specific substantive direction. On the flip side, you've got the regional policy statement, which has Chapter 6 and Objective 6.2.1, which is framed in far more directive and substantive terms. And it's my submission that when looking at those two documents aside, the RPS is the one that must be given effect to in a substantive sense. And that provides no pathway here for this application to be approved. But as Mr. Langman notes as well, he says that even if Policy 8 were to be invoked, this proposal doesn't satisfy the criteria in terms of significance in any event. So look, unless I can be any further assistance, I'll happily hand the microphone over to Marcus Langman.
Just one point on what you've just been saying about the cumulative effect of these private plan changes. Clearly, I'm only charged with one plan change, which I will be looking broadly at the merits of in terms of NPSUD, regional policy statement, and all other relevant matters. If there were decisions that were not appealed, in other words, settled on other private plan changes, then they would be a substantive thing for me to take into account. But at this stage, my understanding is there are not. So I don't have, if you like, any firm position output from other commissioners on the merits of those to take into account, do I?
No, you don't. And equally, there's no documentation before you as to the merits of those other proposals. I'm merely making this comment to you so that you're aware of the potential implications here. And it's a matter that Mr. Langman's addressed in his evidence, particularly in relation to wastewater. The evidence for Selwyn is that there are feasible upgrades available for this particular proposal to enable it to be serviced by the Pines wastewater treatment plant. But of course, if 8,000 dwellings come online and then the medium density standards need to be adopted by Selwyn in August of this year, that number will significantly jump. And so there is a wider potential downstream implication that should be considered. Now, I appreciate the spot you're in. In my personal view, it probably would have been better for one commissioner to perhaps deal with all of these out of sequence plan change requests so that there was one decision maker with oversight. But you're not in that spot. You're here to make a decision on the merits of this proposal, and that's your task.
To be fair to Selwyn, that was their intention, I understood it originally. However, the pressure on pushing these through, partly triggered by the bill's deadline, has resulted in the situation we're in. So, yeah.
Look, I mean no criticism either. I can appreciate well and truly the resource and constraints that Selwyn will be under, particularly in the midst of a district plan review process as well. And I can only anticipate that there are also subdivision applications on foot for similar out of sequence developments, but I'm speculating there. So look, no, that's just merely agreeing with your comment that you are here to determine the merits of this proposal, not everything else. But these councils, of course, are concerned about the potential for wider implications to result.
Okay, why don't we move to Mr. Langman? There may be matters that come back in your directions to Wakefield from discussion, but I think we should move to Mr. Langman and see where that takes us. Are you guys hearing me clearly enough at the moment?
It's tricky, Commissioner. Yeah, but I think we can get there.
It wouldn't help if I started singing or anything like that. No. We're not making it clear, will it? How are we doing just in terms of the timetable before we go to statement? What are we supposed to be doing around that now?
You had morning tea scheduled for 10:30, sir, and we're now at 10:11, so I think we can probably.
Thank you for the help. We can carry on. We need a reference point to at least what part of the day it is. Mr. Langman, welcome.
Thank you, Commissioner. There we go. Look, I won't. I've got a brief summary of evidence, and I've had the opportunity to review the planning summaries and the summaries provided by the various witnesses for the applicant. Look, in summary, in my evidence, I address the planning issues in relation to the proposed plan change, including how it relates to strategic planning for Greater Christchurch, the framework for the higher order planning documents, including the NPSUD and the CRPS. And in particular, as we discussed, or as you've discussed with Mr. Wakefield, Chapter 6. So the key issues that I reach in my conclusion are that the additional yield that's provided by PC 72, when looked at in the Greater Christchurch context, does not result in additional development capacity. The immediate area, including the subject land, is already planned for rural residential development through the rural residential strategy for the district. And if the proposal proceeds, that it will place pressure on further expansion of rural residential potentially elsewhere by reducing the amount of rural residential provided within the district. In relation to the housing capacity assessments that have been undertaken, there's sufficient development capacity to meet expected housing demand over the medium term. And the proposed, in terms of the proposed housing typologies that are proposed by the applicant, they don't go far enough to align with the housing needs stated in the housing capacity assessment, which seeks a slightly greater range of smaller household units and so forth. That may potentially become, or may be overcome by the medium density residential standards. However, that's potentially going to be limited by the extent of developer covenants on the site, and I address that a little bit as well. The request out of sequence with the planned infrastructure development in terms of the projected infrastructure boundary, and I understand that you may have some questions around the infrastructure boundary as well, and the implications of the medium density residential standards, which are implemented by the Resource Management Amendment Act, haven't been taken into account in terms of capacity within Selwyn District, as I understand. While the contribution to development in terms of this particular plan changes, I consider to be minor and not significant. I think it's the cumulative impact of this and other further unplanned greenfield expansion, which will likely compromise opportunities for intensification elsewhere in Christchurch. The government has targeted intensification of existing urban areas through the use of the medium density residential standards. And one of the reasons for doing so was to be more productive and efficiently use urban land and reduce pressure for urban expansion and sprawl into greenfield areas. And that includes onto highly productive land. The primary relief in Plan Change 72, which I outline my evidence, is essentially that it doesn't implement Objective 621, 622 of the CRPS, and as a result of that, it also doesn't implement or give effect to Policy 631, which seeks to keep that development within the identified FDAs and greenfield priority areas for Greater Christchurch, which are shown in Map A. The consequence of that is that there are a number of provisions in relation to the Selwyn District Plan which are not implemented through the proposed change, and I further on note that the plan change applicant hasn't sought to amend the objectives or the policies in the plan to that extent. So the zoning in effect, granting the zoning in effect, doesn't implement those objectives of the plan. I explained in my evidence the reasons why I think the Chapter 6 of the CRPS and the NPSUD can be read together. And in my opinion, there's nothing in the NPSUD that can be interpreted to override the statutory requirement to give effect to the provisions of the CRPS. And taking into account the higher order documents that the higher order planning documents in terms of the NPSUD and CRPS, as well as having regard to the rural residential strategy for the district and the provisions of section 32. I think just in terms of this particular development, the living free zone, which is identified by the proponent as the least preferred option, is the most appropriate for implementing the objectives of the plan and giving effect to the higher order documents. Just in terms of the applicant's planning summary and responding to it, I just note that the following points of disagreement. Ms Aston considers that the development of the Birches Road park adjoining the site has changed the urban suitability of the site. To that extent, I disagree, and I know that Birches Park is proposed to retain a general rural zone in the Selwyn District Plan, and in particular, there's a strip of land between the site and Birches Road, which will remain a general rural zone as well. I disagree with both Mr. Cleese and Ms Aston to the extent that it's not appropriate to consider additional capacity at a greater Christchurch scale because it would create a bar that is implausibly high, and that's the wording in Mr. Cleese's report, such that a pathway provided by the policy could never be used. Just on this point, in relation to Plan Change 69 to the operative Selwyn District Plan, which seeks 2,000 households, I presented evidence that the quantum in that situation could be considered significant. Ms Aston says in her summary that PC 72 is consistent with the objectives of the SDP, except as they relate to those which restrict urban development to map A greenfield priority areas and FDAs. As a result, as I mentioned just earlier, as a result of the plan change processes, such changes to the SDP could have been sought, however they haven't. It's therefore difficult to reconcile how the provisions are most appropriate for implementing the objectives of the SDP. Ms Aston describes the rural residential strategy as outdated. However, I note that the strategy is intended to apply for 10 to 15 years, and that's referenced in the rural residential strategy. Although I accept that the document states that it would be reviewed within 5 years, and I'm not aware of the reason as to why it hasn't been reviewed. I do note that the rural residential strategy describes the subject land, which is identified as Area 8 in the rural residential strategy. And what it says in relation to areas 4 to 8 is that they are small contained nodes where appropriate boundary treatments are required to integrate the sites into both the urban and rural environments. There are definitive road boundaries, physical features, or established land uses that reduce the potential of ongoing urban sprawl, avoid adverse reverse sensitivity effects, and on the urban form of Prebbleton coalescing. Avoid adverse reverse sensitivity effects and the urban form of Prebbleton coalescing with Lincoln to the south and Christchurch City to the north. So effectively, the rural residential areas are used as a boundary tool for Prebbleton, and that extends to the west of the site and along the proposed plan change area. It also states that areas 8 and 9, so this particular area is area 8, in achieving the long-term compact concentric urban form of the township. The area assists in achieving the long-term compact concentric urban form of the township by assisting to establish a permanent peri-urban edge to Prebbleton, north of Hamptons Road and west of Toswell Road, respectively. So that really sort of outlines the reasons why rural residential development has been identified in that area. And just also noting that notwithstanding that there's a need to go through a plan change process to rezone the area to Living 3, the area is identified as a rural residential growth area in the proposed Selwyn District Plan, and not as a full urban area. And I maintain the position that rural residential areas shouldn't be seen as transition to full urban development, and that Living 3 remains the most appropriate zone for achieving the objectives. At para 41 of Ms Aston's summary, she couldn't find where change 1 would give effect to the MPSUD in the Minister's letter. I understand that the legal position of the MPSUD is that it's secondary legislation under the RMA, and a reference to anything being done under an Act includes anything done under legislation, and I've got a reference to the Legislation Act in relation to that. So when the Minister has stated that the proposal complied with the RMA, that also applies to the MPSUD. Ms Aston focuses on Objective 3 of the MPSUD as justification for expanded greenfield development of Prebbleton. However, there are other methods to achieve delivery of supply. And you touched on it earlier in relation to that supply can be undertaken through development of brownfields areas and through intensification. And I think that, in my view, is the intention of the medium density residential standards which the government has introduced, and which I've noted in my evidence seek to reduce pressure for urban expansion and sprawl into greenfield areas. So it's twofold. It's a two-pronged approach in terms of in terms of that. I accept Mr. Colgrave's response in the summary that caution should be applied in terms of assuming any immediate drastic rise in housing capacity through the introduction of the Ndrs, and that position was supported by Ms Aston. I think the proportion of housing capacity that's been realised in previously urbanised areas and undeveloped areas, i.e. essentially intensification and greenfield areas, is one of the matters which the MPSUD directs all councils to monitor on a quarterly basis. So that enables firm data to be provided as to the uptake of intensification, and that uptake will obviously not occur until after August 2022, or if the councils bring that the MDRS in earlier, or the IPIs to enable that. But very quickly it will become obvious as to whether through the monitoring as to whether the MDRS is having an impact on uptake of intensification and supply of housing. I think the other point to note on that is that given that the housing capacity assessment identifies that across Selwyn, CCC and Waimeka area there's sufficient development capacity, I consider that the opportunity is there to monitor uptake. It's there, the opportunity is to be responsive in relation to that monitoring. And I also think that monitoring will provide sufficient data to feed into the spatial planning exercises undertaken at a regional level, and the subsequent review of the CRPS, which I just note is scheduled for 2024. In terms of the impact of NDRS, I maintain my position that there's insufficient information around that and what that will mean for development of new residential areas, and the subsequent capacity for network infrastructure being put in place. And so that relates to both traffic and things such as wastewater. So absent developer covenants, there's the potential for greater levels of development to take place than that assessed by both the applicant and the council, and that could place pressure on infrastructure capacity. And I'm not aware of any, I don't recall any mention in the evidence as to whether developer covenants is something that the developers are looking to implement. But it seems to be fairly standard practice across Selwyn and new developments within the city. I think there's little comfort that the proposal will have or enable a variety of homes that meet the needs of different households unless the developers commit to not including developer covenants on matters which the Ndrs seek to overcome, including density, building coverage and height. Ms Aston and I disagree on whether the proposal will support a reduction in greenhouse gas emissions. Ms Aston compares the site with other development areas in the district. However, the proposal is in addition to these areas, it doesn't substitute them and therefore reduce emissions. No attempt to quantify emissions has been made or comparison made to travel distances within Christchurch, where there is a substantial opportunity for intensification with easy access to public transport. Given additional employment is not proposed by the development, it's expected that private vehicle commuting levels will remain the same, if not higher, as a proportion of the population of Prebbleton. And just on that note, when looking at the plan changes in relation to Prebbleton, which I outline in my evidence in terms of at paragraph 79, there's three plan changes, 68, 72, and 79 in Prebbleton, and combined those provide a total of 1,520 households. And I think that's slightly higher because I think the proposal here now provides for slightly more than the figures in that table. So I think it was up to 320. So an additional 30 on top of that. So just in terms of the implications of that, and I think we referred to objective 6.2.2 in relation to Prebbleton and the discussion there. What that objective seeks is that those townships provide for self-sustaining growth. And I think the important point here is that no additional business development is proposed within Prebbleton. So it's very difficult to call that self-sustaining growth in terms of a township. I think the scale of the town really sort of needs to be relative to the employment opportunities that are available there as well. Otherwise, it risks just turning into a commuter suburb as opposed to a sustainable town in its own right. So just in terms of that, I think that probably completes the summary of my evidence in response to questions, and I'm happy to respond to any questions.
Thank you very much, why don't we start with the projected infrastructure boundary? You've actually put somewhere in your evidence in a footnote, which I found last night in rereading through it. The suggestion is that projected infrastructure boundary, well, let's go back
Yeah.
to the evolution of chapter 6.
Yes.
The evolution of chapter 6 came out of pre-Cape work on a Christchurch development strategy. I've got the name not quite like urban strategy. And was seized upon to be implemented through the LERP, which shortcut lots of processes and put a chapter 6 into the regional policy statement, when my understanding is that would not have otherwise occurred in that way but for the event of the earthquake.
That's correct, yes.
So the effect of that was to release a huge amount of land very quickly for rebuilding and recovery.
Yes.
And at the same time, it incorporated, let's be clear, we're doing this, not something else, i.e. we will avoid expansion in other areas policy provisions. Now, we're kind of through that phase, aren't we, in terms of what that was really all about? Are we through that phase of rebuilding or recovery, in your opinion?
To some extent, yes. I mean, there was a quite a significant loss of housing in Christchurch, which necessitated immediate action, and that was one of the reasons for essentially dumping quite a large supply of land and making it available for development through the land use recovery plan. So to some extent, yes. So I guess the next step following that was the development of our space, which is which essentially sets out locations and where further development would be able to occur. And so the next step in that process was the identification of the future development areas, which were then included through Change 1 to the CRPS.
In that regard, you will have looked at the proponents' evidence in relation to the supply and demand of land in the Prebbleton environment.
Yes.
And basically, well, there's various bits of evidence there from valuation to economics to real estate, which have to be pieced together.
Yeah.
Now, some of that is, in terms of price rise, is of course quite recent.
Yes.
But seemed to me to be reasonably compelling evidence, and I don't have the other evidence to the contrary, that there is a serious supply problem in the Prebbleton settlement. Do you accept that?
Just in terms of the supply of housing, potentially, yes. I think the evidence of Mr. Sellers was that there's currently only three vacant sites on the market, and very few available to be developed. I think that's my recollection of his evidence. I think the point that it's difficult to determine what the issue is with price in relation to Prebbleton. And I note that just in terms of the site sizes for 2021, so there was the biggest supply of greenfield land in the last 5 years in 2021. So, in his evidence, the average site size, I think, was approximately 856 square meters. So we're talking about not small parcels of land in terms of urban development. So these are quite significantly different from the 350, 400, 200 sizes that you might get in various other areas around Selwyn District. And I just know that that's also an average. So there'll be quite a number of sites that are significantly larger than that, and there may be some that are smaller than that. So while there might have been a price increase in terms of the land, it's difficult to I guess determine whether providing significantly more land will actually well, actually I shouldn't say significantly more land. Another 300 sites is likely to reduce the demand, or sorry, reduce the price of that land. The other thing I know is that just possibly in terms of Prebbleton, one of the factors that's probably worth noting is that for quite a number of years there's been significant odour issues with mushrooms. So I'm not sure that which closed down in I think 2019. I'm not sure that that's created the image of a desirable place to live necessarily. That again potentially having now changed with that factory closing down may have changed the desirability of that township to live.
Yes, I understand that. That's as I understand it, there are some set retirement villages now under construction from my thorough site visit at 5 o'clock last night. which will, if you like, change the density mix in the town as a little bit as a whole. But I think there's 2 retirement villages under construction at the moment in terms of overall density, looking at the character of the town. But, yeah. Okay, so coming back to the projected infrastructure boundary, seems to have been something that evolved out of the initial chapter 6 and what areas of land were capable of being serviced at that time. And from what I see, so it appears to be cast in stone right through into plan chain 1. Now, what Selwyn District Council are saying is, well, we can service this area of land without major difficulties, and we have future plans for increased capacity that will certainly cover the future development areas and probably further growth beyond in the various 3 water areas. Why is this projected infrastructure boundary still a relevant matter?
As you'll know from my evidence, the projected infrastructure boundary doesn't have a policy basis within the RPS. There's no reference to it apart from in Map A. So it's not to be seen as an urban limit. What my understanding of that as it was inserted into Map A at the time of the LERP was that it reflected the infrastructure boundaries and that were identified in the council's 30-year infrastructure plans. So that enabled certainty of investing within particular areas with a 30-year horizon in terms of development. I think the key thing in relation to the infrastructure issue is the cumulative impact of all of the plan change proposals if they all get approved, and what the consequences of that are in combination with the medium density residential standards and the ability to service that. And I'm not sure that particular issue has been necessarily addressed. And I discussed, yeah.
Every local authority in the country at the moment is servicing what could potentially be triggered by the medium density residential standards.
Sorry, I had difficulty hearing that.
So I was just commenting that I think it's a problem nationwide.
Yes.
In terms of 3 waters capacity, particularly let alone transport, for implications of the medium density residential standards.
Yes, it is. Yes, yeah. I think it's probably partly highlighted. I think in evidence from Mr. England that the just in terms of the capacity within the Pines wastewater treatment, I think there's further consenting and expansion required to that. And although that's funded, it's not yet consented, and it's potentially some time off. And I think the implications district wide in terms of the cumulative impacts on approval of all these plan changes, I think it's a relevant consideration to take into account. As to capacity.
A lot of your premise is, hang on, we're going to do a new spatial plan.
Yes.
Let's not preempt what that should be doing. Countering that, of course, is the circumstances of individual private plan change applications and their merits. If they are compelling, then there may be a case for saying, no, this is good enough, we don't need to wait for your musings on a further spatial plan. This passes the test, and that's obviously what I'll be grappling with. Yes,
that's right. Yeah, and I think that also comes back to those key questions about whether the plan changes provide significant development capacity and so forth. Yes, it actually meets the requirements of those responsive policies.
Now the other factor I wanted to just tease out a little bit with you is the whole. So the regional policy statement has targets for intensification.
Yes.
I remember the policy number. do you have a feel for how, probably the housing capacity assessment or whatever will have considered this, but how that has been going? Are you on those levels?
I haven't. I don't know the extent to which those the exact figures are being reached. Given the monitoring requirements of the NPSUD, that information should be available, and if it would be helpful, I could inquire of the regional council as to the information relating to those particular figures, if that assists.
Well, I mean, we're in a different intensification environment now, or there will be as provisions are required to change over the next year. But it's a little bit of self-interest here. The land use is partly my background here, and Marcus might recall that I had a role in developing what was called the Enhanced Development Mechanism, which was forced into the Christchurch City Plan in discrete area locations to enable medium density development, particularly where there was residential demolition caused by earthquake damage. And it required a certain really kind of coalescing 2 or 3 sections. I don't know what that threshold was, 11 or 1200 square meters or something, which triggered a significant medium density opportunity, still consentable.
Yes, yeah.
And it was we weren't labelled as the month of Christchurch City at that time, and they thought their garden city was being put under threat, or what they think now in terms of the NPRA. But do you have a feeling as to how successful that was, and did the regional council resist? I mean, because it had a sunset, or it was applied with a sunset clause and fell away at some point.
Yes, but that was the enhanced development mechanism.
Yeah.
I'm not aware, and I'd have to inquire through the consents team as to whether that particular mechanism has been used. So that was effectively a floating zone, which enabled residential medium density zone to be applied in particular locations which have locational constraints around the city. I think possibly there's been, given the quite large areas of residential medium density that were rezoned as part of the district plan review, possibly the ease with which those could be developed has probably provided for the focus for developers in terms of intensification. So I'm not personally aware of the EDM or the being used, but there may be circumstances where it has.
I may say a somewhat more sophisticated mechanism than government. There we go. Brownfield sites is also a feature of the evidence in terms of potentially affecting opportunities of brownfield development. What have we got left in the they would mostly be in the city? We'll be all in the city, I think. What have we got left in terms of brownfield? I think plan put in a brownfield overlay, didn't it? I think in the replacement district plan. I mean, what the question is that still now a material issue, or have we pretty much worked up all our brownfield overlay opportunities, and were there very many in the first place of the plan recognized?
I'm not too sure of the answer of that. I'm aware of a number of sites where there's potential for brownfield redevelopment. There's a significant site next to Hackley Park, the old stop sale yards, which hasn't yet been developed. But I expect, I mean, brownfield land, whether it's identified as such, there's other opportunities in terms of industrial land and conversion of that to brownfield development. So there are opportunities within Christchurch City to undertake that brownfield development. I don't have any really tight sense of the exact extent or potential yield of those brownfield areas. I just probably know that the opportunities that are recognised in the housing capacity assessment recognise that there's significant opportunity for intensification still within the city, and those are set out in tables 1, 3, and 4 within the housing capacity assessment.
Well, and finally, you mentioned somewhere in your evidence the City Council Social and Affordable Action Plan.
Yeah. So my understanding is that that was at the time of the submission that was a point of submission for the councils. I'm not sure that anything's been progressed, and I haven't focused on that in my evidence. So it was just a note of that was one of the positions that was put forward in terms of the submission.
All right, that's good, thank you. Mr. Wakefield, do you want to come back on any points from a legal point of view from that discussion? Oh.
Look, thank you for the opportunity, but no, I don't think I do have anything to pick up from that conversation, unless you've got any questions arising. I think we're at an end.
Well, there's only one point that I meant to ask you about, and it did relate back to your legal submissions, and it was the sort of King Salmon type cascade of documents issue. It strikes me that King Salmon clearly was about a superior, higher level in the hierarchy, national policy, state, coastal, coastal environment, directing the whole kind of avoid meaning policy for resource consents at the time, actually. But wait to be given to that. But the situation we find ourselves in a little bit right now is kind of the reverse, where you've got an NPSUD saying be responsive, and we've had a good conversation. Listen to what you said about what you think responsive means, but a regional policy statement saying, well, no, we want to avoid expansion beyond our existing areas. So we kind of almost got the reverse of the King Salmon situation between those two, haven't we?
Yes and no. The NZCPS does itself have very directive policies, which we'll all be familiar with, and then it does also have other policies which provide significant flexibility to your lower order regional and district councils. So the NPS is a good example of a higher level policy which contains language that can be interpreted and applied in different ways. The distinction here is that the NPS doesn't contain those avoid directions or the strong language that the NZCPS uses. And so it does create this different framework, which then needs to be given effect to within your lower order documents. And what we say is that without that directive language, it still means that there is flexibility for the lower order RPSs and district plans to give effect to what that document is trying to achieve, with recognition of the sub-regional context that it's required to manage.
Yes, on the sub-regional context in this particular situation. Yeah. All right, thank you very much. We could probably go on talking about this the rest of the morning, but I will resist that.
I'm more than happy to if that's what your preference would be, but equally morning tea is probably quite appetizing.
Well, it probably is, and we don't have a strict limit to our time, but certainly want to use it efficiently. So thank you very much, both of you, Mr. Lane and Mr. Wakefield. This was a very helpful contribution. Thank you.
Thank you.
Thank you.
Right, we will adjourn to morning tea. Morning tea that is, of course, just me having a glass of water. No, seriously, in terms of the practicality of getting a copy from McDonald's or whatever, it's only reasonable for me to give you time to reasonably do that. I don't know what the experience was yesterday. We have a few people here. It's now 10 to 11.
I think just in terms of efficiency there, I think the applicant's quite happy to have a 10-minute break, have a cup of coffee, maybe that rest, the and then come back. So we don't delay others.
Okay, so, well, let's be generous and make it 15. So we will commence again at 15, which will be 5 minutes past 11. Is that all right? So we adjourn now, reconvene 5 minutes past 11 for those who are listening, watching, If you would like, we make some space.
Yes, shall I do a hand character?
Well, I don't know if you need to make taking
Not
time.
at all.
There is 3 of us.
There's 3 of you. Sorry, preempted this and sorted that out.
I've just been told that only 2 of us really need to sit up.
Thank you. Yeah, we've just been relocated. We have this section that's written. We have evidence table from Mr. Fletcher. We had some engagement yesterday with the hearing on stormwater matter. And Mr. Brennan, well, over to you, Mr. Fletcher, really to conduct how you want to play that.
Thank you. So my thought had been to just do a basic summary of where we're at and based as well on what we've heard yesterday as well.
Now you can take the mask off at this stage.
That's a good idea.
The audio has been a bit difficult this morning.
Fair enough.
And please put your microphone on.
And press your
Even
button.
better.
All good.
Okay, so I was saying that I'll do a bit of a run through on what we've heard and sort of our concerns and thoughts, and then we'll. My plan is really that both Grant and I are here to answer any questions you may have. Grant's the person on the ground who has the intimate knowledge of the property. I do have some photos, one photo, and also a plan showing some levels of the area.
Okay. We'll make sure that the proponent gets a copy of those. Appreciate it. Lovely, thank you.
Now, even though the aerial is double-sided, that was courtesy of the photocopier. They're exactly the same on both
Oh,
sides.
it's the same.
Yes.
Okay. It wasn't a very sunny day when you took the other one.
I'll run through that one in a little minute. So, yeah, it is a little bit more unique for the Drinnans as a submitter, in that we'd like the question of stormwater to be addressed, but we'd also like to include a portion of the property as part of the plan change area.
Yes.
If you'd like, I see you're looking at that plan now.
Yes.
I'll run through that with you.
Yes.
So Grant has the necessary equipment and technology to take levels on his property. And so what he has done is taken various levels just to show the fall between different points. So you'll see up in the left-hand corner, running along the southern boundary of the property, there's a line saying a 700mm fall. So that is the drop from that top left-hand corner down
into the area marked A. And so that area A is at the ground level, as I understand it, in the property, and the pond, which you can see in the bottom right-hand corner, that's part of the creek which runs through there.
So that body of water we can see at A is part of the stream of what is its name? Crossland Stream. Thank you for that.
So that's obviously lower again, so about 1.5 metres lower. And again, what one can see is there's a 900mm fall from that left-hand corner to you really call it the end of Hampton's Road. If one was to go from that corner of Hampton's Road across, there's a 600mm fall.
1400
And yes, and on the angle to where the channel leaves the Drinnan's property from Hampton's Road, you can see there's a 1.4 metre fall across there.
And that channel was flowing north from there, wasn't it?
You would say, well,
And then went a quarter and went east from that other plan.
So the channel actually, you'll see where it's marked 600mm fall. So at the end of that line, up the top end or the northern end of that line, that is where the channel starts and runs across in an easterly direction. It is worthwhile pointing out that there is no channel running along. I think it was in the evidence of Mr. Blakey.
That's right.
Yes, I think it was below paragraph 16 on page 4 of his evidence. There was a light blue line shown. It's my understanding, Grant to be able to confirm this, that there is no channel or drain running along there. And likewise, there is no channel or drain running along Hampton's Road, which has also been marked on that illustration. And while we've got that that image, which has also got the pink line, so what happens there is when the building was constructed, as I understand it, it was intended to dispose of water to the ground. I think it was constructed before Grant purchased the property. Yes. And what Grant found was that that building had been constructed in a low point on the property. So yes, that pink line exists, but it's incorrect to suggest it's for the drainage of the building. It's so that the water doesn't pond around or in the building in that shed.
So that's more of a drainage of land to the north of the house and building.
Just so
to avoid ponding there.
Just so you can keep your stock food dry and so on as well. Now, the other image I provided to you was a photograph on a beautiful sunny day. That was during the, I mentioned 3 rainfall events. This is during the 68 mil rain event. This was a picture taken at the end of the rain event period. So Grant was interested in having a look to see if there's any water flow. Now, just to position you where that picture's been taken from. So on the image, where the channel runs, approximately halfway along that fence line is a gate and a fence. That is where the picture has been taken, and it is looking to the west. So that is looking towards the
Looking west, is it?
Yes, towards the plan change area. And so what happens is the actual channel, as I understand it, is within the grass area. You'll see a black stocked water drop.
Yeah.
And if you were to come back towards the point where the photo is taken, you can almost see a subtle line in the grass. So it's not within the brown fenced area, it runs parallel, and it's very difficult to see. Would you like me to draw it on an aerial for you to be able to see?
Yeah, no, do that.
Well,
I can see some holding water sort of halfway down that fence line.
exactly.
Right. Okay, I didn't see that from there. So that's good.
So I'll just, I appreciate that it's difficult to see.
Oh, I see. Okay, so what I've been shown is a line parallel and only a metre or so from the double fence where the shop is running parallel to that fence. So I can pass this on so it's available to others. Actually, now I see it. I'm happy to pass it around. Okay. Now,
So
I just noticed on the aerial that there appears to be a sort of vegetation difference or some feature that runs roughly behind where the photo is taken from. In other words, at an angle is that just any note? Do you know what I mean?
Yes, that is the continuation of that swale.
That is the swell.
From that gate where the photo was taken.
Yes.
To the west. That's if I spun around 180 degrees and took another photo along the swale, that would be it.
So that's what you're calling the swale.
Yes.
And then it goes right.
Yes.
So, and as I say, that photo was taken May after a heavy rainfall event.
Now, the point probably here to get to is we had this discussion about natural certitude and so on, was whether this was drainage from your own land or to what extent it was actually coming from the adjacent property and how that generally relates to historical drainage patterns of the issue.
Yes. So I'll run through that a little bit. I thought it was just useful to point that out. And that aerial photograph is somewhat out of date in that on the left-hand side of that aerial where it's marked 600mm full, there's obviously a driveway running through there these days, which you'll see on, even for example.
Yes, I did look at that yesterday very briefly, where it was, yes.
So the point, if you like, is that during a heavy rainfall event, there is no water flow running through that channel. But I'll run through that a little bit more. So in my evidence, I note that the Drinnan's property is approximately 10 hectares in area. There is the reserve currently being developed. And that reserve has had quite a critical impact on the area, I would suggest. In that I'm unsure if you've seen the plans for the area.
Well, at least the overall concept.
Yes. So they show sports fields, lighting, and also a dog walking park and so on as well. The sports fields will have lighting as well. And so the proposal for the reserve, that was a designation application, and that was publicly notified. The Drinnans made a submission on it, not really in opposition, just trying to ensure that the reserve was developed as per the plans, and also there was a little bit of a concern about Hamptons Road. What if there were more cars coming down there, and the maintenance of that area? Would the road be sealed? Not the whole length of the road, just that portion of the reserve. But yeah, there was quite some discussion around that, and even at that point, I assisted the Drinnans and we made a submission and just highlighted the fact that the character of the area was going to change as a consequence of that reserve. You would have seen that Hamptons is a dead-end road of a gravel formation in that end.
It is public road.
It is public road, but it is maintained with unmaintained public road.
I'll ask council about that later.
Mm-hmm. And you would have also seen through our original submission that there's the leg of land for the Drinnan's property, which was sought to be rezoned.
Yes.
So moving on to the question of stormwater, at the end of the day, the issue for the Drinnans is that right now there's a development which appears to be placing a reliance on draining stormwater across their property. And the approach of the applicant to date is that the water flow will not change, natural servitude and so on. But what appears to be the case, in my opinion, is that it's a very broad analysis to say this area gathers this water, comes down, flows through the Drinnan's property, because right now that is not the case because of the works that were the driveway that was formed, 10 or so years ago. And and also materials which were stored on that property as well. So that's the impression I get as not an engineer as to why you can have a heavy rainfall event and there's no water flowing across the drainage property. What you do get is on the plane change block area down at the corner where the road ends, you get a ponding area, you might say, with some.
Yeah, okay.
So that's where the water's going. And that will steadily fade over time. So you can imagine for the drones that right now in heavy rainfall events, there's no water coming across their property. And so when they're told that nothing will change as a consequence of the development, they struggle to understand how that's the case. Struggle to understand how you're having a ponding area and the water is being directed to their property, but it will not change from what it is now. If one wants to bend their heads a little bit, it might have been in the case after the 1950s when a drainage ditch was constructed as per my evidence. Might have been. And that was then changed by the landowner who built the driveway and so on, stored the material. So it's not a natural waterway. It wasn't there forever in the day. There is you might say, a natural sloping across that area. But there has to be a point at which you say, well, yes, there was drainage, but then that was stopped 10 or so years ago. So does one actually have the right to restart?
Yes.
Which
Abandoned natural servitude.
Well, and as I say, you've got to even be careful referring to it as natural servitude because it wasn't there originally. It was only once it was constructed in the 1950s and then in effect taken away.
Yes. Now, I mean, clearly at the plan change level, we're not going to get into the detailed design of the stormwater management areas, which is a specific engineering task. But I get your point. Did the discussions with the proponent yesterday afternoon help in any way?
To be honest, not really. And what was made very clear was that the calculations have not been undertaken. So I asked the question of what, like with the 68 millimetre rainfall, I was asking, is that a 1 in 50 year event, for example? And they hadn't done the calculations yet to work out if that was the kind of rainfall one could expect. So yeah, and there is a very fine balancing act, but there is also the concern that if one, say the plan change gets approved and so on, is there the risk that come the next hearing or regional council consent or whatever, that they say, no, we showed stormwater flow in the plan change hearing, we showed that and it was fine. I've been in hearings where the same commissioner initially in the first hearing said that's an issue for later on, and then the next hearing said that should have been dealt with in the prior hearing. So there is that nervousness, and there is a preference with the Drennans that the matter is resolved, whether it's more data, whether it's even finding an agreement as to process. You might say, you could have, these are the steps that will be undertaken to determine the impacts on the Drennans and what the appropriate solutions are. There is no such process right now. So, and as I say, one could just relate it back to if you were the landowner and somebody said, I want to drink water across your property, you'd naturally have an interest in understanding what the impacts are on you. And that's really what they're trying to achieve right now. Now, I appreciate that you've visited the area, but if you are wanting to go on to the Drennan's property, by all means, you are welcome to do so. Thank you. So that's the stormwater element, and I appreciate we haven't sort of done any questions as such yet. So in terms of the rezoning, to be honest, your site visit probably explained more clearly than anything I can say here why it was logical to include that strip of land. It is only appropriate to rezone that strip of land if the plan change was to be granted, goes without saying. And it is only more appropriate because of that reserve on the adjoining land. It completes the sequence. There appears to be within council general support for the inclusion of that piece of land. But there is sort of a question around services. The impression that we are receiving from council today is that there isn't really any significant consequence in including the land from a water supply, effluent disposal perspective. We are happy to look at that further if so requested, and it might be a good question to discuss with both Mr. Murray and Jonathan Clay. So we're happy to help, get the necessary reports if necessary, but right now it's not abundantly clear that they are required. And then in terms of, there was some discussion around pedestrian access between the reserve and Hamptons Road. There's not really any concern with that, some kind of inclusion, but I'm talking to Brennan because he works a lot with the council as they develop the reserve next door. He just wants to ensure that it goes in the right location. And so my suggestion would be that one could either say include on the outline development plan, here's a very approximate line, and you might label it as indicative location, or you might make sure there's an assessment maker that shows, requires the provision of pedestrian access. We're reasonably comfortable with either option, but we'd just like to make sure it works in with the design of the reserve and the sports fields and so on. Because also in reality, if one was to subdivide this piece of land, then you're going to have to provide a reserve contribution. So a reserve contribution could easily be a pedestrian access between the two areas. It's just whether you elect to, say, have some kind of assessment matter, or if you prefer an indicative line on a development plan.
Now, our outline development plan at the moment has, I suppose, pulled back on what it's on some areas like the medium density stuff to get some flexibility and if you like, beef up the narrative in that regard. I think there are potentially design issues that need to be resolved in terms of outline development plan. I've raised the issue of the interface with the park and how one might really orientate physical development. I sort of do see as a sort of issue that an ODP should be giving some guidance on. I'll see what the council officers have to say about that. But I think there's opportunities to be maximised in a quality design for that type of land. And though it's a reasonably discrete area with very clear access, it's not just carry on without having regard to us, given the approach that ODPs take. So just to make clear, that's the area that I have some reservations about, or one of the areas I have some reservations about. There may be some other technical areas in terms of suitability as well. But clearly, I need to be very careful that we are if we're putting something in place, that it is consistent across the plan change in terms of the issues that are addressed. So I'm very happy for you to kind of comment and respond to that, but I'll also be seeing what the officers have to say about that as well.
I guess I take a little bit of a pragmatic approach in terms of if development was to occur, it's a significant asset having an outlook over the reserve area and so on. And so I would like to think, can't guarantee these things, but I'd like to think a subdivider would take into account both in the design of the subdivision and the position of buildings. They're going to want to seize that opportunity, you might say. So, to some degree, it's going to happen, but certainly beyond that, any subdivision would require a resource consent, and one can look at the assessment matters and determine if the current assessment matters would be adequate already to address that, or it would appear to be fair and reasonable that you might have some more specific assessment matters. Just for example, fencing might be a good example, where you might either have some kind of provision on the plan which controls the fencing or possibly the setback distance between any building and the boundary. I do appreciate what you're suggesting, that one does need to be careful about the interface between the two areas. But just because it would be an attractive element to the area, I suspect it's going to sort of happen anyway.
On the lighting issue with the reserve, presumably the designation incorporated appropriate lighting, shading of lighting conditions.
I can't remember off the top of my head, but I'm pretty sure they do. But the interesting thing about lighting is I was talking to the council project manager, Phil, and he was saying that they have problems with modern lighting these days, and that you have your sports field extremely well illuminated, but the lighting is so focused that they walk off the sports field to go to their car in the car park, and it goes pitch black. There's no light between the sports field and the car park area. So I suspect that with modern lighting, there won't be an issue with the light spill in such a situation. It's just technology these days. But in terms of outlook, seeing the lights, yes, that they are there, they're part of the designation and so on as well.
And the other aspect, of course, is noise. If you've got extended highlighting in a residential environment space there, some people love it, some people don't.
Yes, some people do love it, some don't. There's two things to keep in mind. One is that the area is already designated, that those activities are able to legally occur. Any development to join them is not going to prevent that. But also the reality is that a lot of reserves, training fields and so on, are all in residential areas. It's pretty common characteristic. So noise and lighting are common elements of a residential area as well. And when the Drinnan submitted on the original designation application, they pointed out the fact that they will be able to hear people training. So there will be increased cars on Hamptons Road. They will see the lighting, but they were accepting of those things.
Hamptons Road isn't proposed to use for any access to the park at the moment, is it?
What I suggested was that parents on a Saturday sports morning will park as close as they can as to where their child is playing a sport. So there are sports fields adjoining Hamptons Road. If I was a parent taking my son to football, I would park along the road edge. Yeah.
Good. Anything else?
No, that's all the points I had. And Grant, do you have any?
No, I think you covered them pretty well.
So it's essentially whether you've got any further questions.
It is, isn't it? All right, this is the question. The question is the question. I have got a list of questions there, but I think we have pretty much covered them in the conversation we've had. So unless there's anything else you would like to add, Mr. President?
No, I think it's been well covered.
Very good. Okay. All right, thank you very much indeed. That's excellent. Right, let's look at the clock. I got this watch a few years ago. I thought I should upgrade my watch. Not very good. I can't see the jollies.
We don't have a clock for you.
Oh! You tell on the board. 12 minutes to 12. Okay.
We're really focused.
Now, let's how long do you think we're going to be at the council?
Well, I wonder if we only make a start, like Mr. England, who's here, who can talk to sort of pre-water, stormwater.
Yes, that's correct, Mr.
So I thought we might start with Mr. England, especially given the conversation on stormwater, Repeal was mine.
Yes.
If we got Matt Collins on transporting Zoom me,
Yes.
I think we'll be reasonably short as well.
Yes.
Then Hugh Nicholson next to me on urban design, and then me, and I've got sort of reference up again. So I did wonder if we make a start with sort of Mr. England, Mr. Collins zooming, and then maybe reassess how we're tracking.
I kind of feel that probably if we were happy to have a late lunch, or in other words, finish, we probably would be done around 1 o'clock. And if that's acceptable,
That'll be my feeling as well.
we will probably get there, but if a common speaker reason, you think you're happy with that? Everyone who's watching happy with that? Okay. So, I'm very happy with you there. What are your sporting activities?
My sporting activities. Sailor. There's another marine sailor that's not me.
What's the reason? You've got it. It's going back roughly 4 years when my son was sailing, yachting, and there was definitely another evening from Christchurch who was sailing. He was right on the water.
It's funny. Every now and then I get that question.
Do you the marine?
No, that's not me. I do enjoy skiing. But
Yeah, okay. That was well spotted. Okay, over to you. Sorry? We good?
would you like me to read my summary of?
Yes, I would. I can read it before.
Yeah, so I can talk about that. Okay. So my name is Murray Russell England, the skier, not the. Yep. I'm here to state my evidence dated 15th December 2021. As an officer of Salvage Council, expect to plan change to the Salvage plan. My qualifications and experience is set out in that statement. I now provide a summary of evidence which addresses the water supply, wastewater system, and stormwater network operated by council, which might be impacted by this plan change. Water supply. The Prebbleton water supply provides untreated deep groundwater to the Prebbleton community. Prebbleton is expected to grow over the next 30 years. Capacity upgrades are proposed to meet this growth, including additional water sources, bores, storage, and pipeline construction. I consider that additional capacity within the network services plan change can be made available with further capacity upgrades proposed and planned for, and therefore future water demand for the proposed plan change can be met. The reciprocation of water supply to the proposed plan change will need to be designed to meet 5 standards. Wastewater, Pines Wastewater Treatment Plant. Wastewater is treated and disposed of at the Pines Wastewater Treatment Plant. Pines Wastewater Treatment Plant involves them. The Pines Wastewater Treatment Plant is designed to be progressively updated or upgraded to accommodate up to 60,000 personal equivalents a year. Not only Implied. The plan to increase the treatment capacity up to 120,000 population equivalents per year, and we're calling it the Pines 120. The current connection network catchment as of this year is a population equivalent of around about 42,000 to 45,000. There are plans to expand the irrigation area to cover 302 hectares, currently irrigating around about 189 hectares. This equates to servicing more than 120,000 population equivalents, or just over 100,000 population equivalents at the largest irrigator that's not operational. Ultimately, additional lands within the 486 hectares of land owned and consented could be developed for land-based disposal or remaining in compliance section of the development wasteful network to the council to particular network with the Prebbleton to your pump station is feasible. This will be subject of an engineering approval process in the future. Lastly, in terms of stormwater, it is anticipated by the applicant that stormwater will be managed within a constructed stormwater management program, SMA, providing first-class treatment for the first 25 mils of rainfall, continuation of all storm events up to and including the 60-hour duration of the ARI event. Roads will be used as secondary flow paths, with the primary network being designed to convey the 10% AMP. The proposed management of stormwater is appropriate and will be subject to further investigation as design and review should plan change be approved and the development process moves to engineering approval stage. The status of the stormwater outfall from this development has not been fully resolved at the time of voting statement. The ODP should either show the legal stormwater outfall from this development, or the ODP narrative should include the need to confirm and secure a legal outfall from the development.
Thank you very much. So, from an LTP point of view, as opposed to a Christchurch regional policy statement or plan change plan or whatever, the council has been planning for growth, and the council, that includes growth of Prebbleton. What sort of parameters have been placed around that from an infrastructure sort of planning point of view?
I'm not sure quite understand the question, but I suppose in terms of planning process, we carry out the long-term plan every 3 years, and that could look out over a 10-year horizon. Part of our master planning, we develop hydraulic models, we look at growth predictions and bits and pieces. So from an engineering point of view, we probably take a conservative or conservative, but we overestimate what the growth would be. So we know that this is certain growth predictions that are happening, and then we always get a level of that, if you like, to that system. In terms of Pines, the wastewater treatment plant, I did some work looking at all the plan changes were approved, and the existing areas that are already zoned were to occur, would end up with around about 120,000 population from the discharges of Pine. So I took that sort of optimistic sort of view, saying that, well, so the worst case feels, and the worst case, if it doesn't improve, how we manage that. So we're looking at that sort of basis. The truth is that we have been growing exceedingly fast, and I'm not sure we're the fastest growing district, but we're always very close to being the fastest growing district in New Zealand. And we don't expect the growth to slow down anytime soon from an engineering point of view, so we always want to make sure we're just in time getting our infrastructure in place. So we do take an optimistic worst case project, but also look at the worst case and building our infrastructure and planning to meet those things. Prebbleton's a wee bit interesting. So Pines treatment plant, we're happy with that. We've got capacity all planned out over the next 10, 30 years to meet that growth. That's fine.
And that's what you're saying is that that expansion can fit within the framework of existing consent.
That's my position. Correct. We did get consent from Warwick Entry, but that's that's our.
Well, that was a point from the planner for the council of Calgary, questioning, I think, whether that was funded and planned for, but not necessarily consented. I think it's the point you made on this morning.
So there are a range of consents. Yes. I have a couple of this evidence I have for the plan change, which was joining the Pine Street plan. So there's only earthworks type consents to acquire, so building the structures and the station works to do that. We discharge the air consent we need to obtain for the extra capacity. And then the question comes down to the discharge consents on our land. So original consent application, as I recall, well, I wasn't there at the time, but from reading it, did say that we'll be discharging up to a certain amount of population equivalents on that land. The consent itself talks about the loading rates and the loading of nitrates on that land. And so the treatment system involved is probably far superior than what we proposed to at the time, and so we can exceed those population equivalents but still meet those discharge requirements. So that's the nuance in our application.
Those are pretty dry and
Correct.
right.
So we're as council, we're reasonably comfortable that we can obtain those businesses. So I'm personally comfortable with compliance in my opinion, that we can consent that and can carry on growing. The next issue is conveyance. So Prebbleton pipe pumps through the fuel pump station through to Rolleston to be treated, and that pipeline has a limited capacity. And so in my full evidence on page 6, responding as well, the right place. So running at the time, there is capacity on the Prebbleton fuel pump station to set flows on the plane change. However, there are other plane changes large consistent with plane change, including PC 68 and 79, and capacity may not be available for all. So each of those plane changes will take on its own merit. I know that there are potential engineering solutions, and I'll list those in the evidence to upsize portions of the rising main, increase pump size of the pump station. It may be that when this development happens and with Aboriginal approval, that additional storage is provided with the pump station pumps up to the pump station so that we can buffer flows and pump off peak. So we're not discharging wastewater all at that peak time, everyone's getting up, taking a shower, all then come home, then we can sort of hold that flow back for an hour or two and discharge it through. So for this plane change, I'm comfortable with the pacing the flow through.
And I think you say somewhere in your evidence effectively on a first served basis. In other words, if you come forward with a subdivision application, which might only be for a stage, and you get engineering approval associated with that, until you need to, and then the more, I suppose, the rate at which that you're always looking ahead a little bit of what you need to do in terms of pumping capacity and so on.
Correct. So it's really interesting. All these plane changes went on the radar when we wrote the last LTP, which is only just into effect. And so once we get the outcome of these plane changes, we'll be able to look at our master planning again and revise that.
Yeah.
Correct. So that is no issue.
I'll raise this again in word this very projected infrastructure boundary that's been, if you like, a bit of a fence that was determined some years ago about, where it wasn't really numbers, it was more geography. It wasn't like we can service this 1,000 people at this point in time, and that's our planning, which is what you might expect if you like infrastructure plan to be. So this is the land that we will service and nothing else. Sort of thing. Is that sort of what's currently in the regional policy statement as that kind of hard line that relates to avoiding urban development outside? It's still a relevant tool in your point of view? And it's a sort of a planning question, but it comes down to infrastructure sort of planning as well.
Yeah, I'm probably not as limited to those planning boundaries as perhaps the planners are. That said, if I use Rolleston as an example, we've got this sort of structured plan area for Rolleston, and we've used that as a boundary for designing infrastructure. So every time we step out of that, it's going to be a redesign. And I suppose for this plan change area, it's the same. It's sort of outside. It's not necessarily easy to hook onto our particular wastewater. It is going to require a designated, dedicated pump station to pump up to where we can take it. So we haven't taken into account for our planning this area, but there is an engineering solution to work around that.
Yeah.
And then part of it, like the water supply, we have resources to extract water. And review that capacity and consent, and I'm satisfied that we can service this plan change area of water, even though it's outside of that boundary line. Whereas for Wollaston, I've done the same calculation, you can only service within that structure plan area, and any plan changes outside of that will require their own consent report to be transferred to council. So the boundaries are useful in some way, but in this particular case, there's still workarounds.
Yeah. All right, and stormwater is the other matter. And you've said that the outfall, that the ODP should be a little bit beefed up in this area, I think is what you're saying. What you're saying is that a sort of a right to convey that water across that property boundary is something that is required, which is not what the proponent is saying. The proponent is saying on a natural servitude basis, it's not going to be any greater peak flow. A peak flow and public flow, of course, not the same thing. Two things down one, but and therefore we don't need a legal, if you like, we've got that right in place. And as long as we don't go beyond that in our detailed design, then we're okay. What probably you're saying is, well, you don't know yet what your detailed design is really going to function like, and that matter needs to be addressed. Is that kind of where you stand?
Yeah, that is. I can probably use some examples. It's probably not a typical situation we come across. So if we use Wollaston, discharge of stormwater to the ground, and so each subdivision is required to discharge up to 50 UOB to the ground, and so theoretically, no stormwater up to 50 UOB actually leaves that site, where in this case, there will be. In other cases, like Lincoln, Ricky subdivision, for example, there's a physical classified drain that can discharge to the boundary, and so storm is accumulated in the wetlands and then discharged into those drains. So you actually have physical discharge, be it pre and post flow means the same. So in this case, what I was saying is not a fine, clear outfall across the neighbouring property. Whether it needs to be dealt with at this stage or at future stages, I don't know. That's probably a planning question. But it does need to be identified as an issue and needs to be addressed at the next stage. So we good to provide some sort of indication in the ODP that this will be addressed, or just some sort of reminder, I suppose. I know it's not planning, but it needs to be acknowledged that this matter hasn't been fully resolved. The other thing I would say is, and I'm not a lawyer, and so you probably get some legal advice on natural servitude, but my understanding is that it's a case law type basis, and it seems from my previous experience as a storm engineer, the case law does change on the situation. So some papers on case law that I've read talk about if you concentrate the flow in one place, that's a great thing. It means that the downstream property owner can actually take that flow easily and transfer it through their property. Another case law I've read that talks about, well, actually, you want to keep it as natural as possible and it should be dispersed. So I've seen two applications up in the Rodney area, one where I've concentrated all the flow from Belmont into the downstream property and through a pipe, and then the other case was where they actually put fuses across the boundary line so it's kind of across the fuse now. So what I'm saying is that it's not necessarily clear cut. I understand the idea of natural servitude and it makes sense. It's a natural flowing of water and servitude on the person below to set that. But how that should be and how that should be discharged onto that property and through the property, I think needs some consideration. But whether it needs to be done here or at the next stage of recent consent, I'm not sure.
I mean, look, I think it is very much unless there are such constraints that challenge the merits of the claim change, then it is a matter principally through design and agreement, and whether that and it may well require certain agreements and rights to be put in place. Process with the Drinnans, which is what they were really looking for, is a little bit more certainty. But Yes, I think a flag in the ODP is what you're saying as an issue to be resolved, and therefore it's not, so it's out there, is what you would recommend. Yeah, okay. All right, thank you very much, Mr. England, who's here not to say that. Excellent, thank you very much.
So I think we need to go to Matt Collins, who hopefully is available on Zoom. He has also emailed for a statement, summary statement. So pass that around.
Good afternoon, Mr. Collins.
Good afternoon, Commissioner.
Well, that's happening. Because we haven't met before, but I don't know, I was obviously in the motel overnight. I don't normally watch breakfast television unless I'm in the motel. And on the breakfast news was the chap Matty being taught to play guitar. And it was an example of teaching older people, younger people teaching older people to play guitar. And the gentleman identical to you. It wasn't you, was it?
Sorry, Commissioner, I missed a fair bit of that, but obviously it was quite humorous. So.
All right, I was just saying that on breakfast television this morning, there was an article on TV1, Breakfast TV, that was about younger musicians, professional musicians, teaching older people a new skill, which in this case was playing guitar. And the guy that he had been teaching for 6 months was absolutely identical to you.
Oh, really? No, I think it'd be somebody else teaching me to play guitar.
It's very much the side, but just while the papers are being handed out. Thank you. You provided a summary statement.
Yes.
Perhaps you could read that through.
Would you like me to start from section 3, where I get into the nuts and bolts, or start from section 1, where I outline my experience and qualifications, etc.?
Section 3 will be fine. Thank you.
Sure thing. So section 3 is a summary of transport matters. I've reviewed the following statements of evidence and summary of evidence from the applicant, that being Ms. Williams as a transport engineer and Ms. Ashton for planning. I've reviewed the following evidence from submitters, being Mrs. Wakefield and Hayden on behalf of Canterbury Regional Council and Christchurch City Council. Unless otherwise discussed below, I consider that matters identified in my transportation hearing report, which is attached as Appendix B to the Section 42A report, have been resolved through evidence from the applicant's experts. In my view, the following transport matters remain in contention. First being the provision of cycle facilities on Trices Road and Hamptons Road frontages. The second being the mechanism by which safety effects at the Trices Road, Birches Road intersection are assessed and addressed. The third being cumulative effects on the wider transport network. And the fourth matter being minor amendments to the ODP narrative. I discussed these matters in the following section of my summary statement. So the first matter being the provision of cycle facilities. In section 5.4 of my transportation hearing report, I recommended that the outline development plan identify walking and cycling facilities along all site frontages with Trices Road and Hamptons Road, and that a safe pedestrian cycling crossing point be identified on Trices Road near Stonebridge Way. Mr. Cleese supported this recommendation, and reference to that is paragraph 103C of the Section 42A report. In paragraph 36 of her statement of evidence, Ms. Williams considers that the ODP narrative specifying a requirement to upgrade these frontages to an urban standard is sufficient to allow consideration of cycling facilities. I support the wording of the ODP narrative in this regard. However, I recommend that the ODP plan shows cycling facilities along these frontages and a safe crossing point on Trices Road near Stonebridge Way. As higher volume and higher speed corridors and to provide good connectivities for cyclists, these facilities are required to ensure future residents of Plan Change 72 have multimodal transport options. And I note that Mr. Nicholson, acting for Council on Urban Design Matters, supports my view. The second point is safety effects at the Trices Road, Birches Road intersection. In section 5.5 of the Transport Hearing Report, I recommended that the applicant provide minor safety improvements on the Trices Road eastern arm of the Trices Road, Birches Road intersection prior to any new intersection being formed onto or any direct vehicle access being formed onto Trices Road. Mr. Cleese supported this recommendation and the reference in the section 42A report is paragraph 102. However, he considered that this could be addressed through the subdivision consent process. In paragraph 13 of her statement of evidence and paragraph 7 of her summary of evidence, Ms. Williams supports Mr. Cleese's position. I agree with Mr. Cleese and Ms. Williams that further assessment of methods to manage safety effects at this intersection can be undertaken at the subdivision stage. However, in my experience, there is a risk that the subdivision consent process may not adequately address the cumulative safety effects. And this is particularly if development within Plan Change 72 area is staged. The requirement for safety improvements is not in contention, rather it is the mechanism by which these should be secured. In my view, the ADP narrative should be amended to identify that the applicant is required to provide minor safety improvements to the Trices Road, Birches Road intersection prior to any intersection or direct vehicle access being formed onto Trices Road. The third issue in contention is the cumulative effects on the wider transport network. In paragraph 6.3 of his legal submission, Mr. Wakefield identifies a concern with the cumulative effects that multiple plan changes within the Selwyn district could have on the wider transport network. In paragraphs 128 to 140 of his statement of evidence, Mr. Langman discusses this concern in more detail. In paragraph 38 of her statement of evidence, it should read, Ms. Williams provides her response to this matter and considers that planning and coordination of the road network improvements to accommodate the cumulative growth is a matter to be addressed at the district and regional level. In my experience, out of sequence development, as referenced by Mrs. Wakefield and Langman, creates complex challenges for councils and road controlling authorities. Assessing the effects of such development on the long-term planning and funding commitment associated with bulk transport infrastructure is complex and requires assessment of multiple land use scenarios. Helpfully and independently to the multiple plan changes that are currently active within Selwyn District, the council has engaged a transport planning firm, QTP, to assess the transport effects of 2 future land use scenarios for the Selwyn District. The QTP analysis compares future growth scenarios. The first scenario is a baseline scenario using forecasts agreed by the Greater Christchurch Partnership Committee. The second scenario is essentially scenario 1, but it just adds an additional 10,000 dwellings into the Selwyn District. I discussed the preliminary findings of the QTP assessment in section 4 of my transport hearing report and my view of out of sequence development in section 6 of my transport hearing report, which I summarise below. Should Plan Change 72 affect the quantum of residential growth within Selwyn without a corresponding increase in local employment and access to services? Additional impact on the Greater Christchurch transport network can be expected as additional residents in Selwyn travel to access services and employment. However, the wider effects of out of sequence plan changes, such as Plan Change 72, may not be overly apparent on a micro scale macro-scale regional transport model. And this is because the vehicle movements generated by a plane change naturally distribute across the transport network, and the further they get from the source, being the plane change, the smaller and smaller the proportion of traffic becomes. I'm therefore of the view that while Plan Change 72 will likely have effects on the wider transport network beyond those assessed by Ms. Williams, these effects, including cumulative effects of other plan changes, are more appropriately addressed at a district and/or a regional level. The final matter which I consider in contention is just minor amendments to the ODP narrative. So Ms. Aston provided a revised ODP narrative in Appendix A of her summary of evidence, and I'm suggesting several minor amendments. The first amendment, so the second to last paragraph before road frontage upgrades reads, all roads will be provided with a minimum 1 footpath to provide a safe pedestrian only alternative. In my view, this sentence is not required, as the provision of footpaths for new roads is directed in council standards and guidelines. Further, I'm concerned that this sentence could be used to justify an argument for only 1 footpath in a situation when 2 footpaths should be provided. The second amendment that I'm recommending, so the second paragraph after road frontage upgrades reads, in addition, a shared cycle pedestrian path is proposed along part of Trice's Road between Birches Road and the primary north-south road to provide a connection to the existing rail trail. As I've discussed in section 4 of my summary statement, I consider that the ODP should direct that cycle facilities be provided along the full length, the full frontage of Trice's Road and Hamptons Road. I'm happy to answer any questions you have.
So most of your recommendations relate to various tweaks, changes to the ODP narrative, mostly the narrative. Which there isn't any overlap between the minor amendments at the end and the more substantive recommendations for changes to the narrative in your earlier sections. They're quite separate matters, aren't they?
I think so. In terms of my, in terms of section 4, where I've discussed the provision of cycle facilities, there is overlap with those amendments in section 7. The way I've sort of structured that is I haven't put forward any suggestions for changes in my section 4 or section 5. And my section 7 is merely just commenting on what's been put forward by Ms. Aston in her her evidence.
That's fine. Just on the QTP modelling, scenario 2, which is scenario 1 plus an additional 10,000 dwellings, presumably that looked at a specific distribution of those dwellings amongst the centres and so on. Can you tell us it's probably in your report.
Yes.
Or you can just refer me back to the report only.
Yeah, the QTP report does discuss that. I'd need to look up the exact reference, but essentially what they did was they used a multiplicative factor. So they proportionally distributed that additional 10,000 dwellings relative to the scenario 1 distribution. So, if Rolleston had 1,000 growth and Prebbleton had 500 growth and nobody else had any growth, then it would have been that 10,000 would have been distributed as 2/3 to Rolleston, 1/3 to Prebbleton, for example, for that additional housing. So it didn't change the distribution, it just changed the magnitude of growth essentially for Selwyn.
Pro rata increase that to distribute that 10,000.
Sorry, what was that, sir?
If pro rata distributed that extra 10,000.
Correct.
In terms of the percentage across the settlement.
That's correct.
Usually that did allocate some growth to Prebbleton because
yes.
The regional policy statement and indeed the proposed plan. Well, while there is some final phases of growth being constructed at the moment, including 2 retirement villages, but there isn't really longer term planned growth on the table other than these plan changes at the present time.
Yeah, so from what I understand, the QTP report did it anticipated forecast growth based on the identified infrastructure boundary. So obviously some growth in Prebbleton, some the growth focused in Prebbleton, Rolleston, a small amount in Lincoln.
Yeah. Well, there isn't a lot of further growth within the infrastructure boundary for Prebbleton that can be. But I'll have a deeper look at your report and the QTP and get my head around that.
Certainly, Sarah. And after I've finished my presentation, I'll dig through the report and pull out some references and send them to Mr. Cleese to assist your reading.
That would be helpful. I mean, the outcome of that is not pivotal in that it is you're saying is that well that's for a bigger picture assessment. It's just if you like being clear in my mind what has been attached to Prebbleton growth as part of those exercises. That's the matter I'm just trying to be clear on. And it's not a matter you're saying is critical, but
sure thing.
Prebbleton doesn't get any growth. Thank you. Thank you, Mr. Collins. I don't think I've got any other questions. So thank you very much indeed.
Thank you, Steve.
We have done, we're up to Mr. Nicholson. 25 plus 12, so I think we're doing okay. I think Commissioner's stomach is rumbling too much, unless that's coming through. Perhaps that's all the disturbance on the audio. Okay, sorry. Now, Mr. Nicholson, you've had the pleasure of being here for the hearing, which is good. So you have a clear insight to the issues. Thank you for preparing a summary. Go for it.
Thank you, Sir. For the record, I am a skier and a sailor, but not a boat. And I don't play the guitar.
Good, I'm pleased you got it.
So, my name is Hugh Prebbleton. I'm an urban designer acting for the council. I have prepared a memorandum on urban design and landscape matters for the council with respect to Plan Change 72. I have reviewed the applicant's expert evidence and considered submissions on the plan change. So this summary highlights areas of agreement with the applicant and any outstanding matters of disagreement. I consider the proposed plan change is an appropriate location for urban growth that links Prebbleton with the new district-wide reserve on Birches Road and rezones a block of rural land which has residential land to the north and the west and the new reserve to the south. In general, I consider that future spatial planning exercises allow a more comprehensive range of options to be considered, together with the relevant costs and benefits, compared to private plan changes. They also allow for more meaningful public engagement to be undertaken and used to inform the spatial planning exercise. In this particular instance, the Council's development of a new district-wide reserve on Birches Road establishes a new urban structure for Prebbleton. Instead of a spatial planning exercise, is unlikely to reach a different conclusion with regard to the use of this land. The applicant has made changes to the ODB in response to the issues raised in the Council's Section 42A report. In particular, I support the Living Z zoning being extended over the whole site to a minimum density of 12 households per hectare, a continuous east-west connection through the site, and the upgrade of the Crisis, Birches and Hamptons Road frontages to an urban standard in accordance with the Council's engineering code of practice. After discussions with Mr. Collins and Ms. Lauenstein, I recommend that the ODP should include a single continuous primary road running north-south and an additional continuous pedestrian cycle connection running north-south, using the stormwater management area in the southeast quadrant of the site and the local road network in the northeast quadrant of the site. This will ensure that if future residential development to the east is not approved or is delayed, then there is still a good level of connectivity between the wider Prebbleton village and the new Birches Road reserve. The text of the revised ODB requires a shared cycle pedestrian path along part of Crisis Road between Birches Road and primary north-south road, the length of the existing rail trail. I understand that there's been some discussion regarding rerouting the rail trail off Birches Road and through the new Birches Road Reserve and PC 72 to Stonebridge Way. I recommend that shared cycle pedestrian paths should be provided or retained as part of PC 72 along Birches, Crisis and Hampton Road frontages, and that a safe crossing point on Crisis Road should be provided near Stonebridge Way. In terms of the rural lot south of Hamptons Road, Ms. Lauenstein and I agree that its scope and technical considerations permit it would be appropriate to include 5 rural gates to the south of Hamptons Road owned by the Greens into the plan change as part of the Living Z zone. If this is possible, I would recommend that a cycling pedestrian connection is provided through the additional land connecting the stormwater management area and the southeast quadrant of the plan change area directly to the new Birches Road reserve. In my opinion, the proposed plan change will have a moderate to low impact on the landscape character, reflecting the change from a rural residential landscape with a small number of houses and a predominantly natural character to a residential landscape with a higher number of buildings and a suburban character. Bearing in mind that visual quality is one of the attributes that contributes to landscape character, and that the site is largely surrounded by existing shelter belts and ditches, in my opinion, the visual impact of the plan change on the adjacent houses on Crisis Road and Birches Road will be low. This reflects the wider landscape character will change, there will be no significant loss of views, and there is an existing rural residential character. I consider the visual impact on the house and property at 2 Hamptons Road will be moderate, reflecting the length of the sheer boundary and the change from a rural character to a suburban character. This is partly mitigated by the setback of the house from the boundary. I note that the owners submitted on the plan change. In terms of submissions, loss of identity and changes in the character of Prebbleton is a common theme in the submissions. The submitters mentioning the loss of a village feel or small town character, or suggestions that Prebbleton might become part of Christchurch. People's sense of belonging or emotional attachment to a place is generally understood to be based on their shared experiences of specific territory over time. Changes such as PC72 are likely to threaten the perception that local people have of their town, and the disruption of existing urban habits and the introduction of new physical and social elements. A significant number of submitters are concerned that the higher densities proposed in the Living Z zone would adversely affect the character of Prebbleton. While the Christchurch City Council seeks that the plan change is declined in the first instance, but if approved, that the density is increased to 15 households per hectare. On balance, I consider that a minimum net density of 12 households per hectare is appropriate in this location, reflecting the benefits of a modest increase in density while supporting the existing character of the Prebbleton village. Thank you, and I'm happy to answer any questions you have.
On the Drinnen additional land issue, the recommendation, and it's accepted by the Drinnen about the additional pedestrian cycle length through to the reserve, which the level of design planning of the reserve that I've seen doesn't necessarily say quite how that would work. But it seems to me that the park itself is going to change a little bit of the whole character. This is a major investment in sports related stuff in addition to the additional domain. It's going to be a contributing factor to the overall appeal and village character of Prebbleton. It's also going to be quite a major recreational asset. The reason for the pedestrian rail, the cycle and pedestrian links, having two of them down through the development of the ODP, is not only access within the development, but access to the reserve. But unless you facilitate that one way or another through agreements, then it may not happen. In other words, if the Drinnen's land is not, one could, of course, negotiate it quite separately of a planning framework. But the question I have for you is ensuring that connection and that connectivity through to the reserve, particularly in mind for younger people who might be going to sport, and a fair bit of focus of the reserve is organised sport, and being able to get there without parents having to drive the jolly cars and deliver them there. Does that perhaps, in your mind, tick the box sufficiently to say, yes, it really is important that we embrace this now, otherwise we have no guarantee of achieving that?
Yes, I think the advantage of addressing the own land now is that we can achieve a comprehensive outcome. And if we don't do that, then we're left with a pedestrian cycle link which arrives and happens right, and then you then have to go, filter down towards the.
You have to go right around or to where the next entrance is. Yeah.
So I would support including that land in the ODP and including a pedestrian cycle connection, in some location there to be determined as part of the future subdivision.
The other factor to do with this is what else would need, in your view, to go into, if you like, the ODP component for that bit of land. And you heard me talking about the interface with the park. There's potential for medium density. There's actually quite a few unresolved issues which one would normally have, if you like, a bit of certainty on now. Do you see the response was, well, the assessment methods can deal with that, and I welcome Mr. Cleave's comment on that when we get to that. But ODP issues, if you like, from a design sense for that bit of land, what are your thoughts on that?
I would like to see some additional inclusions about the frontages to the reserve. The current living Z walls do have fencing walls adjacent to reserves, 50% transparency from memory. I think one of the mitigations that Ms. Lowenstein's talked about in terms of this plan change is that the applicants seek to create a higher standard of edge treatment. In my opinion, that's probably best dealt with through developer covenants and perhaps referenced in the ODP that in terms of consistency of fencing, in terms of the kind of the overall kind of approach, that it's mitigating the effect of the change from a rural residential to a suburban kind of treatment. They've talked about a higher standard of edge treatment. I don't think that can be done easily through the rules. So I think probably a developer
That's entirely at the discretion of the applicant without any control factor.
It can be part of a proposal, though, when it comes to subdivision consent proposal, it can be part of what it is you're saying you will do, not saying that it can't be.
The other issue I think is that while there are rules that are current within the DF zone, and they are proposed in the draft review, the plan review, I guess there's no certainty they'll remain.
Yeah. And the advantage of this land from a design point of view is that it's not constrained by, has a decent frontage to Hampton's Road, it's not constrained by any other dwellings or buildings or infrastructure, whatever. It's pretty much a blank canvas.
It would be great to have the houses addressing the country and looking over the park. And one imagines they would, but you know, that could be a requirement of the ODP.
Yeah. I think dealing with another private plan change where I'm advising the proponent, which has quite a big stream rehabilitation or almost re-establishment of stream there because all of the diversion away from that. And in that case, where we have the frontage to open space, we certainly have particular access arrangements that ensure that the house is addressed in the space as part of the kind of Japan in that case, but same thing. Yeah.
I would support that.
And would you support medium density along that edge?
Probably would. Yeah. Yes. I don't think I'll make that a requirement.
No.
I would support it if somebody proposed it.
What would you support the option of medium density along that edge? Okay.
I have got a copy of the latest plans from the council water reserve. That's the request. They're still quite high level and general.
People are working furiously.
They do show paths which would easily be linked to the proposed paths. They also show where the sports fields are going, and I understand that the lighting, the sports field lighting is going, but that's something in on the full-size sports field. And those are the two areas that are facing the lift. So the lighting won't be close, to the northern boundary and
Yeah, no, I think that would be useful for the proponent and myself. Presumably you haven't had access to that information.
that's the main point. And this is a staging point.
Yes, and we said stage 1 is under construction, stage 2 is being set up.
Yep.
Stage, yeah.
So, and then that's variable ones, but there's all council website.
I've got that one.
Yes.
But this shows connections.
Yes, so pathway movement, movement is what services for the city car park. So no vehicle access to car parks, it's
That's the pathway there.
yes. It's kind of more of a service. Okay. Car park.
Yes. Okay, so what I think it really is the same as what although there may be a few tweaks to this from the version that you have. But what I've been drawn attention to is it does show a pedestrian connection at that point there. But you can't really see without me.
Available on the council website or something?
This was given to me by the council officer in charge of the upgrade, so I not sure what's publicly available, so.
It looks to me like an iteration on from what you showed me and what I did look at
I've got
separately.
3 circular sports fields. Have you got more
Yes,
than
yes,
that?
yes. So the concept doesn't materially differ, it's just the detail in terms of sort of access, which is access from Hamptons Road is what I was looking for, and it shows that, you know. And a service maintenance area up there, which I don't think the previous one necessarily did, and staging. So it's not a massive leap forward.
But I guess if it does show a pedestrian access from Hamptons Road, that is a leap forward in terms of what was currently a closed boundary.
Yes.
The existing thing.
Yes, and I feel like that service maintenance area up there is new too. So they could be copied and made available, probably not time critical at this very moment, and commented on in reply, that would be very good. And the lighting is for the main 3-size football fields on the main area to the south on Beverly's Road.
That's correct.
Pretty big dog exercise area. I mean, I suppose from my point of view, the important thing when I was looking at this previously is this doesn't incorporate, if you like, gymnasiums or seated or anything like that. It is pretty much sports field, street regeneration through it, and yeah, dogs. So the circle of oval adjacent to Hamptons Road is still labelled meadow, future use to be determined. Which means it's going to be a concert venue too. That's just what I'm saying. Okay, thank you very much. All right, thank you, Mr.
One additional thing about the road frontages. So we had a little bit of discussion about road frontages. I think that Ms. Collins and I have been advocating for a shared path along the 3 road frontages around the PC72 area.
Yes.
There's some discussion about what a good high quality, street frontage, urban street frontage would look like. And I think I would be keen to see properties opening onto those roads, so there can be property access off the roads. And we wonder if that could be included in the RMPs, but possibly with a sort of encourage, just recognising that there are issues with property access over rail trails. So it might be an encouraged in discussion with the Southern District Council at a subdivision stage, if we property access on those frontages.
Yes, I have assumed. I'm just going back to the indicative plan, which is indicative and illustrates what can be achieved, but clearly you've got corner sections which maybe have access of the lesser road, not the edge frontage road. But could you have a look at that, and if you like, see any issues with what that was telling you in terms of that sort of frontage connection issue?
No, I was supportive of that plan, but I'm just aware that is not incorporated in the plan change.
So really what you're looking for is a few words in the ODP narrative about direct connection with the street issue.
Yes, supporting the direct connection, and we're in discussion with Southern District.
I will take instructions on it as said that first flush, I don't see any improvement with that.
I do think we would really. I think it's positive from a design outcome point of view, and I think be on the same space there. I have to say, I've just turned down an application in the bin for a retirement village, which had pretty much most of its road frontage with units side on to the main, which is quite a particular road. That wasn't the only reason, it's one of the issues. Just so you know. Good. Please. I'm the fortunate one. I've hardly had to wear my mask before. I'm very conscious of this.
Oh. So just before Mr. Curtis's presentation, there were some questions that you posed to Marcus Langman earlier this morning that I just thought that it might be a good opportunity for Ms. Aston to comment on while they're still fresh, and so that Mr. Grace can hear her views.
I'm very happy to accommodate that.
Thank you.
Yes. I suspect they'll feature and reply, but the advantage is that the police can hear them and so we totally disagree with them program.
So just two matters really. First one was you referred to policies, RPS policy 6.2,
Yeah.
and that encourages Prebbleton to provide a township which is sustainable and self-sufficient, and encourage some feedback on that. Yeah, so it's kind of it's referenced, but it's not actually discussed. So we just make a statement that we support that policy, but we don't really elaborate any further on that.
Yeah.
So I thought it might be, thank you for raising it. I think probably need a little bit more elaboration.
Yeah.
So the townships where this is encouraged, all the other ones are key activity centres. So there's Prebbleton, Lincoln, Darfield and Leeston. And I think that's correct in the RPS, but certainly Leeston and Prebbleton and Lincoln are two key ones in the Greater Christchurch area. So what I push is what is meant by self-sufficient and sustainable growth. The next policy in the RPS is policy 6.2.3 that talks about sustainability. So reasonably narrow in terms of the matters that RPS, all the outcomes and the issues that the RPS addressed on that. And that's to do with again, having a town community and heritage values, achieving quality living environments by building and design, having regard to sustainable values, a range of unlimited sites and uses, pretty, high level stuff, healthy, sustainable, functionally efficient and prosperous developments. In my view, the evidence is that all those matters are well addressed, and we put a lot of effort into ensuring that quality, high quality residential environment. So that seems the context of sustainability in terms of RPS. In terms of self-sufficient growth, I think it's a relative concept. Mr. Land thinks it requires employment to be provided locally. Each township has to be looked in its context, and arguably none of the townships are totally self-sufficient, and even Christchurch City, there's a lot of two-way traffic. People living now working in Rolleston who live in Christchurch City, as well as huge traffic going in the other direction. Rolleston has a very big industrial sort of centre now with some big employers, Ndrs there, Western Dairy, some big employers.
Yeah.
So in terms of Prebbleton, it's correct that there isn't a lot of business land in terms of industrial business land within the actual township itself, but that's exactly the same situation in Lincoln. Lincoln's only got 12 hectares of business land that's never been developed, just sitting waiting.
Oh, really?
I've had some involvement with that, and the owners have never considered it's the right application. And preference other things. So Lincoln likewise doesn't have any business land. And yet Lincoln is a key activity centre. We did talk about the function of Prebbleton within the township network of Southern District in some evidence within the proposed district plan on definitions, which referred to an activity, township activity network, which is in the council's district development strategy 2014. And if it's of assistance, we can refer to that evidence. Where we, again, that district development strategy is a bit out of date. 2014 predates in particular. It is post-Implied, but it predates the motorway, which was impact on Prebbleton. I suppose really what I'm saying is you don't necessarily have to have all your employment or wage a portion of it locally to be self-sustaining, because the township is seen within the context of, I mean, Christchurch City is self-sustaining, but the distances to deploy here within Christchurch City are as big, if not bigger, than the distance from Prebbleton to the surrounding areas where employment is provided. The other thing is, in terms of PC72, encouraging self-sufficient products, obviously more population housing is supplied locally, and certainly that's happening at Prebbleton at the moment. Fortunately, the central area of Prebbleton does have some room for growth in terms of commercial activity and in terms of zoning, and there is development underway at the moment. There's two quite significant commercial developments. I think I would reference in my evidence. That's
I was going to ask what sort of scale. It was reminded when I did the site visit last night that it had been something on my list to be clear, but it be mentioned in some of, I think, the values evidence or whatever, that there is new building work going on in the centre, and I could see where that was happening yesterday. What is the order of scale of that? Do you know?
Are you referring to the commercial development? It's called Prebbleton Village.
Yes.
Yes, there is I've only looked at the link online, but it does seem to have a range of tenancies which provide services, cafes, retail outlets.
So it's retail and cafe and so on, with small size tenancies for that, with that sort of things, of which you see quite a few.
The website does say as well that I think there's only a couple of tenancies still available, but it has been taken up.
Okay.
And obviously the two new retirement villages provide additional employment. Yeah. So
do they include rest homes, or are they purely villages? Because it's the rest homes that provide control. We could do some that are pretty much department people, I don't know.
I think that's apartments, but the other no fire.
Yeah.
That was just some further information. And then the other question or discussion was about intensification, and I think it's in my evidence that actually intensification is happening in Christchurch City, notwithstanding the greenfield development, but they're both happening. Intensification is happening at quite a significant scale at the moment in Christchurch City. There's quite a lot of different things. And in that housing capacity assessment 2021, the intensification targets for Christchurch City are actually being met.
They are being met. That was one of my questions. doing another target thing there.
Yeah, so I mean, we can again, I don't really want the housing capacity assessment, I need that for this sort of information. And then finally, the legal advice was that the view was that the wider growth strategy is all about intensification, not greenfield growth or catch growth, it's up and out. So it's about in terms of what new development strategy we're trying to achieve. So it's not one or the other, it's fine.
And in that regard, if you read carefully Mr. Langman's evidence or a summary, talking about the spatial plan, it was that, well, the spatial plan will identify areas for new greenfield. I think it says in this, so it's not just, no, we shut the door on it.
It's fine.
Let's do something different. Okay. Yes. All right. Thank you very much. That's good.
Right, Mr. Cleese has, thank you, Mr. Cleese has handed out his summary.
So starting at paragraph 4, I wrote this out sort of last night, so it's sort of, I'll mostly read it, but I might depart here and there to respond to things that have come up during the day. So paragraph 4, the starting point is that the site has long been identified as being suitable for rural residential development or a living free zone at a density of 1 to 2 households per hectare. Such an outcome, in my view, is wholly consistent with both the RTS and the approved plan. It is likewise not affected by the Housing Supply Amendment Act, which is a large lot zone. So there appears to be no argument among planning experts that this option aligns comfortably with the policy framework. We are dealing with this, so that's the starting point really, is that rural zones at the moment long identified for rural residential, even on the same page,
but not for this effect.
Yeah, but not for the effect yet. But that's a rezoning for living free densities. There's no issue with consistency with the RTS or the district plan. So that's kind of the starting point, I guess. And that does differentiate this block from a lot of the other floor plan changes that have been considered by council.
Yeah.
When identified for living free, as we've heard, and I think it's important to reiterate, it was intended that this block to form the southern edge of the township by forming a low density transition to a rural zone or for 4 hectare lifestyle blocks, which tends to be the typical form of a plains rural zone. So all living free zoning outcomes are in place on the western side of 50th Road off to the side. As you're now familiar, council has recently acquired 22 hectares of Bridges Park immediately south of the plan change site. Look, in my view, this materially changes the site context in terms of township form. The park now forms the southern edge through providing a green open landscape with secure tenure, and therefore provides, in my view, an effective long-term edge solution. 2072, in essence, looks to reassess how best to fill the gap created by the park. That is, with the park now forming the town edge, is the real density living free still the best use of this gap, or is a high yield and suburban outcome more appropriate? And that, for me, is the key question before you. It's very easy to call out the capacity numbers and, kind of quite convoluted policy, overlaps and prioritisations. But when you boil it all down, for me, it's actually a relatively simple question of, given the park is now there, we've got a gap to the rest of the town, how best do we fill that gap? In answering this question, it's necessary to assess both the on-the-ground effects of the different densities, so sort of the merit-based assessment that Mr. Whitefield referred to, and also obviously the allowing these options against the wider policy framework. In my view, the regional policy statement as it stands is direct and clear. Urban outcomes outside the area shown on that date are to be avoided. If the NPSUD did not exist, then I would agree with Mr. Lamb that it is a significant policy hurdle to be overcome. But in my view, the NPSUD does change things. That's also the purpose of an NPS, to direct a change in practice and outcome. The NPSUD, in my view, reflects current concern with housing supply, was directed in terms of necessary to help resolve some of the perceived barriers final provision of new dwellings. Policy 8, in my view, opens the door to consider proposals not otherwise anticipated in the plan. Policy 8, however, does not set a bar or take precedence over the balance of the NPPT. And in that regard, I do agree with the language. It's not policy 8, you're good to go regardless. Having passed through the policy 8 door, proposals still need to deliver the outcome sought from the balance of the NPS in order to be approved. And so that's this discussion about the quality urban outcomes. While the RPS has been updated through change 1, as identified by Ms. Aston, in my view, the scope of the change was narrow and did not materially address the text of the policy framework. And I wanted to work at this point. There was a conversation yesterday afternoon around the whole history of self-planning in Greater Christchurch, and I don't want to belabor that. I didn't want to just spend a minute giving you my take on the sort of the evolution of the planning process in Christchurch. I do think it is helpful context for this this discussion on the RPS and how it's come to be in its current form. So, as we heard, it largely started in 2007 with the Urban Development Strategy. So it was an LGA process, and it was the first time that the 4 councils had collaborated, and the whole concept of a Greater Christchurch kind of came into being for planning purposes. So that went through an LGA process, identified growth areas, and then that moved on to an amendment to the RPS to give effect to it in an RMA context, and that's called change 1 to the RPS. So there's 2 change 1s to the RPS, confusingly, there's the 2009 one, and there's a much more recent one. So it's important to sort of terminology of where off that. So in 2009, we had change 1 as was then to the RPS to implement the UDS, and that decision was issued, and then there were appeals. And areas like Preston's and Highfield were originally outside the decision version, but then there were appeals included. Then also in 2000, and so that appeal process was sort of slowly starting to grind its way towards sort of hearings in the Environment Court in 2010. Then before those hearings happened, we also had the youth rights, and that's what changed everything. So then in 2013, we had the LURP, the Land Use Recovery Plan, which overrode the change 1 appeals, and effectively then introduced the change 1 of the RPS, made that operative and bypassed the appeal process, and included areas like Preston's and Highfield that had been subject to appeal. And also, obviously, if you recall, the LURP also at the same time rezoned some of these blocks to the district plans as well, so directly changed by regional and district plans.
There are all the actions in the LURP.
Yes.
Flowed out with that.
Exactly. And the LURP had the LURP had appendices which directed immediate change, and the RPS changes such as finalised, but it also directed actions in terms of steps, further steps that councils had to take. And the living free zone was introduced through one of those actions in the district plan. So we had the LURP 2013, Rural Residential Strategy was 2014 as an LGA thing. And then again, so that because there wasn't a living free equivalent rural residential zone in the district plan scheme at that time, rather than have a whole lot of private planners each coming up with their own idea of what that design framework might look like, council as a LURP action went through a separate LURP action process to develop the objects and policies and rules for the living free zone. And then private plan changes after that, I think we could just adopt those zone provisions for their own. Obviously with the LURP, well, going back, the UDS had growth planning into 3 sort of time period stages, and they're the ones that are referenced in the current RPS language sort of syncing LURP around sort of the mix of greenfield to intensification there. They're split up over 3 time periods. And likewise, the growth areas were sort of identified as being in the 3 time periods. And when the LURP came along, from memory, the 2 kind of shorter time period growth areas became the priority areas, and the long-term growth areas became the land inside the infrastructure boundary. So that's where you asked me today about why they called priority growth areas. It's because they were the areas that were identified to be actioned in the shorter time periods, as opposed to the longer, further out growth areas, because the UDS look forward 30 years. So it never proposed that everything comes along on stream at once. So the short-term areas became priority grid areas, and that's what we see in the RPS. The infrastructure boundary, again, the naming for me is a bit of a misnomer, because it's actually not really about infrastructure capacity. It's simply a growth area policy boundary, if you like, that nonetheless is a useful tool for councils to use in their LTP planning processes.
It was the short, medium, and long term combined as the UDS.
Yes.
Yeah, right.
So that's where that came from. So again, so 14 years old now, kind of that, I think that's
I have forgotten about plan change one.
where these land lines come from. So then we had to learn, we got some actions that came into play. Then we were 2017, 18, we had the NPUDC, which required councils to look at capacity. That led to the R-space process, which again was an LGA process rather than an RMA process, and that recrunched the numbers. And having done that number crunch, they effectively pulled in the land within the infrastructure boundary, the last long-term area, and said actually they can become future development areas, or different word, and that led to change one of the RPS to enable contemplation of those areas again through private plan changes.
Did it embrace all of the land within the infrastructure boundaries FPAs, or was it just, I'm thinking of Boston here, I'm thinking of the plan.
It does. I think there was the residential side, sort of the residential side of the motorway part of Rolston, and actually a long-term picture of it looks like a square.
Yes.
Conceptually, and the infrastructure boundary is the outreach of square, and everything within the square became an FPA. And the only exception to that is the area that's covered by the North contours. Is that sort of we go through the plan change, or are we going to count very shortly for hearing?
The North contour.
So the North contour, so in terms of Boston as a square, the North contour sort of pokes in from the eastern side and takes a sort of bite out of the eastern side of that square.
I was the commissioner who did the change, or I think that Mel did the tweak that came out of that process. It was basically pretty much a agreed solution, however. Noise contours are an interesting bit.
Yeah.
But looking at the plan, the really orangey, pinky sort of colour, as you say, that south wall.
Yep.
And there's 3 areas which are at the but between them are 2 white areas, which I thought well, they haven't allocated all of that.
Yes, I think because I've used that my list of planning process, planning processes in Canterbury. There's also the Special Housing Act, housing forward areas, which also sort of were advanced. So they were advanced as resource consent through sort of caches where the resource consent rather than rezonings. So in all those areas, I think built out the young people their housing, their subdivisions, but they've got an underlying rural design currently. Because we're done resource consent under the cash legislation rather than plan changes. So again, the proposed plans come out, we'll kind of tidy all that up.
Yeah.
Okay,
that does explain that. That's helpful.
Yeah.
Yeah.
So that sort of change one of the RPS, the more recent change one of the RPS, which in my view was quite a narrow change. It was always put forward as quite a narrow change, just to bring all those future development areas in as a result of the R-space number crunch in response to the NPUDC. And that's my view on the degree to which the RPS gives us the current NPUD gives us from that disagreement. Because I always put the change one be a reasonably narrow plan change process. And as we heard, it also went through a fast track process, so it didn't have hearings, so the process is what it is. And the RPS is one of those, but it wasn't a typical RMA process. We then had the proposed plan got prepared, and the proposed plan was notified or prepared prior to the NPSUD coming out. So that's part of the reason why the proposed district plan only includes growth areas that were either identified within the infrastructure boundary, within the change one area, or were rural residential areas, which again contemplated the rural residential outcomes in the RPS. Because when the proposed plan was prepared, it had to give effect to the RPS as the proposed plans do, and the NPSUD wasn't in play. So it didn't have a policy responsiveness lens, I guess, to put over it. So in that sense, the council's hands was retired, and it was a very clear statutory framework at the time. They had to give effect to the RPS. The RPS is the line, and so therefore the proposed plan reflects that line. Then also the NPSUD came out, and in my view, does open the door to contemplate areas that haven't otherwise been identified. That also has given rise to a lot of submissions on the proposed plan, seeking areas outside the RPS, because suddenly that can be contemplated. And it's also given rise to these, we've got 17, 18 public plan changes that are before council at the moment. And again, it's important to me because hardly any of those, virtually none of those plan changes were in play prior to the NPSUD, because it was accepted by Canterbury planning and legal, advisors that the RPS hardline was a kind of a deal breaker. You wouldn't make people like trying to advance the plan change with the framework as it stood. And likelihood of the adjustment council would not be back notification as not being good for resident practice, because he clearly weren't giving effect to an RPS. With the NPSUD, that view has changed, I think, and obviously, the Wakefield's expressed a perspective on that. Obviously, all the legal counsel advising the 17 private plan changes have expressed a different view of their clients. Likewise, selling counsel is has not knocked back any of those private plan changes to notification on the grounds of good residential practice. So, and the observation you made, and that's because I think Sound Council's legal advice is a policy that does open the door to a merit-based assessment. So there's certainly the way of legal opinion out there, I guess, is very much policy that opens the door. Of course, it's not a numbers game. Mr. Wakefield may well be right, but he's sort of a lone voice, if you like. He's sort of helping the currently playing out.
Battling the tide.
Yeah. But putting a good fight forward for us.
He's saying you need to look at it across the board in terms of all the objectives and policies of the NPSUD and all the objectives and policies of the policy statement.
Yeah, look,
I think he's moving a little back from it to like giving privacy to one particular level of one particular policy, even though it is very directed.
Yes.
Look, I'm choosing to interpret it.
Yeah, I think as I said before, that policy aim doesn't override and trump the rest of the NPS.
No.
It doesn't have primacy in that regard.
No.
But in my view, it does open the door to contemplate areas that are out of sequence or not otherwise viable.
Yes, and he used the term as a pathway to assessment of merits, I think, for some of the words that he used. So,
yes, albeit, as I understand from Mr. Lang's evidence, they're saying you provide a pathway, you can notify your plan changes, but the answer will always be no.
exactly, yeah.
So it seems a little self-defeating.
Yeah. Pathway with a locked door at the end of it.
Yes. Yes. So maybe paragraph.
Halfway through 11, I think.
Yes, paragraph 11. So the award policy direction, as we just discussed, might be self-evidently does not give effect to the response framework sought by the NPSUD. In my view, exactly the sort of policy outcome that NP guidance identifies is needing to be amended in order to align district and regional plans with the NPS. I therefore consider that it is appropriate to look through the CRPS to the more recent higher direction. At least in terms of opening the door, I certainly take the point quite strongly that you need to do much more merit-based assessment on the suitability of the land considered. The MPSUD includes a requirement for councils to ensure that sufficient development capacity is provided. And so, as part of the Greater Christchurch Partnership has undertaken such an assessment, and that's the housing capacity assessment of last year. So that's for council's position or council will participate in that housing assessment. Obviously, I'm here as an independent planner to give you my own view on these things. I'm cautious that the assessment understates demand and currently overstates supply for similar reasons that I set out on the support grade. Importantly, the requirement to provide capacity is a minimum. There is no policy hurdle for providing more capacity than what is needed. Provided, importantly, that the location of such capacity meets the other NPSUD policy tests regarding urban form and matters such as integration of infrastructure. So if there are questions over the adequacy of capacity, in my view, you should favour on the upside. And Mr. Lang sort of talked about, it just, the NPS doesn't say you have to provide an abundance of capacity, and I agree with them, to that extent. But I think all the evidence before the audience that I've seen, just a practical, or the anecdotal kind of jumping on trade, we're looking at a number of sections, is that we're a long way from an abundance of capacity at the moment. So I think you could do on the upside by some margin without getting into trouble with creating an abundance, even if an abundance was an issue or a problem. I understand the alternative view put forward by Mr. Langland is that sufficient capacity is available, at least in the short to medium term. And it does imply the timing when they're necessary to undertake a strategic assessment of growth direction for Greater Christchurch and follow that up with a comprehensive review of the CRPS. And that to grant ad hoc plan changes in the interim could result in a suboptimal form and or result in less demand for infill housing in more critical central locations. But this position, of course, relies, in my view, on first setting a high degree of confidence that sufficient capacity is both plausible and available. It also relies on confidence that infill housing and greenfield locations and topologies are readily interchangeable and are therefore able to be substituted whilst retaining a competitive housing market. And I note the economic evidence of the applicant in that regard regarding the local housing market and the limitation of such substitution. As noted in my weekly report, the likelihood of such substitution is likewise raised as being uncertain in the council's own HCA, and I made references to that in my position. The other crucially, so that's the capacity conversation, and then crucially, I think the risk of suboptimal outcome is likewise moderated by the parallel NPSUD requirement to integrate and connect proposed sites into the existing urban fabric. Poor urban outcomes should not pass through to approval. While plan changes might deliver growth in unanticipated locations, such growth should therefore still be appropriately designed, serviced, and integrated with adjacent urban areas, such that the end outcomes will remain acceptable. Such outcomes are also necessarily placed in a wider context of housing emergency where Parliament expects to see a timely response. In my view, PCC2 does provide significant capacity. And I would certainly appreciate that, that subjective capacity term, it is subjective. There's not a lot of direction nationally, as Mr. Whitehall said, no regional council, despite the need to be, as soon as practical, has advanced criteria. But in my view, you do need to look at this significance. I think you can look at both the township, but also step back and look at the district. So I do, to a certain extent, I do agree with Mr. Lang that I don't think significant means you have to have a significant supply in every single individual township. I think where the housing numbers are interchangeable, I think you can sort of step back and take a sort of a no more of West Mountain, but some more Rolleston perspective. But even if you do take that step back, obviously 300 households, and the content equivalent that has about 1,500 households at the moment, is significant proportionally to the town's current stands. I think if you still step back and say 300 households in the context of sort of the inner plains part of the district and so on, that's still a quarter of annual demand for that inner plains area. So I think that, in my view, is significant, especially in the context of the MPs wanting to see or Parliament being wanting to enable housing supply in appropriate locations. So I'm cautious about imposing a really low bar and knocking out proposals in that context. So for me, but it is a subjective term. Mr. Lehman has said, doesn't think 300 is the mark with evidence on Lincoln at 2,000 to satisfy that that is significant. He hasn't articulated what number in his mind is up the threshold for so on. So it is a grey area. For me personally, I'm comfortable that it does have that threshold. And you to open the door if you like to proceed through to a merit-based assessment. Jump straight to 19. In terms of an increase in density yield, so that's comparing it living Z back to living 3, the general site suitability for suburban level density. So this goes to again, you've gone through the door, now the merit-based assessment. The evidence from both council and the applicant is that the site is able to be serviced, is largely free of natural hazards, largely avoids versatile soils, and does not contain any sites or factors of significant cultural heritage, landscape, or ecological value. And we haven't had any technical evidence to the contrary on those matters. The ODP, subject to the amendments confirmed in the proposed evidence, and subject to minor amendments to the narrative to address the matter raised by Mr. Collins and Mr. Nicholson, provides an appropriate development framework. I'll take it through my statement and then maybe at the very end, I'll speak bullet pointing the changes that I think need to make the ODP area that come up in conversation on those couple of days. At the very end, I'll probably, what my bullet point was this, and I'm sure Ms. Eston's been doing something similar. But fundamentally, the ODP is sound, so it's sort of tweaked to the narrative. In terms of forming a logical edge, I'm comfortable with the inclusion of the journal block and that such can be serviced based on feedback from Mr. England. In my view, the plan amendments necessary to include the journal block are reasonably limited. It's a simple change to the plan itself and change the zoning. It moves the ODP to include the site, and then to the ODP, the changes I think for the journals are to show a north-south pedestrian lane through their land and a little bit more narrative on the park edge. The narrative around medium density, already talked about medium density areas being located adjacent to public open space. So I think that holds true. With medium density, if you look at the context here, and with one eye to the medium density amendment that's coming down the track, is that with the living Z zone framework, either planners going to do their ODPs, identify areas on the ODP for medium density. And that means that when their subdivision consent comes in, as long as then they can locate medium density in those medium density areas on the ODP, and that's done as part of the subdivision consent as a discretionary activity, just as part of the subdivision, and the merit of that location for medium density isn't looked at again through subdivision. The alternative route is that they aren't shown on the ODP in areas. There often is some narrative about sort of qualitative criteria. And then at some point in time, there are fully discretionary consent where council looks at the merit of the location of the medium density and the quantum of it as part of the overall subdivision consent application. And there has been a little bit of a change probably in practice and preference over the last sort of 8 or 9 years on that, where initially council very much wanted them to be shown on the ODP, but inevitably subdivisions change, staging changes, and the ODPs council found were becoming a little more clunky with that sort of misaligned. So more recently, the planning preference, probably by applicants and council, actually has been a shift away from showing on ODP, simply moving to a narrative and full discretionary consent pathway. And that's the process that the proposed plan is looking to take forward as well. So just in terms of sort of questions about medium density on the journal block, does it need to be shown on the ODP? I don't think it does. And to not show it is kind of consistent with how living Z zones are developed in practice. So finally,
so you think that compared with the addition of the fencing rule that Mr. Nicholson talked about in terms of fencing reserves and so on?
Well, even then, I don't think needs a new rule of it. No. There are already rules there. Yes, and so it's more the narrative about the interface. And it's very similar narrative in the ODP proposed along the eastern side of the thing, the current abutting rural line. And rather than doing it through rules, it's there is a narrative that feeds into subdivision consent design and development covenants. And again, that's quite a common approach for selling, sort of use of covenants to achieve outcomes and negotiate it through the subdivision process is standard practice. So Selwyn Council is quite different from many other councils in New Zealand, where because it has been such a high growth council for so long, the council sort of staff and systems are very geared for dealing with a high growth greenfield environment. So it's quite different from councils elsewhere that have been low growth, and then they're suddenly whacked by plan changes, and they don't have the systems, their staff aren't really up to speed on it. So it feeds through some of the commentary from Mr. England earlier around, as an asset manager, they are reasonably nimble in terms of sort of adapting to change and have a lot of experience in doing that. And also, just on infrastructure, doing work on procurement growth around the country, Selwyn, or the inner plains part of Selwyn, is a three-wheel infrastructure in particular is always the easiest thing in the country that I've come across, where stormwater is very up until South London, stormwater is straight to ground and really free draining, nice and simple. Water supply, likewise, you drop a bore in, out from the aquifer, doesn't need treatment. Reasonably simple. And during the later changes, there's capacity to measure some consents, as Mr. Allen said. And then for wastewater, council have got pines, they've got the capacity to expand pines, got the land area there, sign the packet plant, we can bulk moisture, so Selwyn is very well placed to be responsive from an infrastructure perspective, and it doesn't in a district have the hurdles that a lot of other districts do, where just the geography makes water supply forward and really challenging. So that just as context, I think that's important, especially obviously you're very familiar with projects, but doing all the work for Selwyn, it is quite distinctive in that regard. One final note on the Housing Supply Amendment Act. In line with the direction given by the Commission on the other recent plan changes, and I think this was referenced in legal counsel for the applicant, the expectation from the Selwyn Council perspective is that decisions will issue on plan changes at densities consistent with what's notified. So your task is simply to get the plan changes before you make a decision, a decision on that. And then leave what we do with the Amendment Act to Selwyn to work through over the next few months, in essence. And to the proposed plan, the residential chapters and the rezoning, because most of the rezoning submissions, 90% of them are for residential zones, council have preferred hearing those until the shape and feel of the residential zones has been clarified through going through the amendment process. So it's for the proposed plan, so they need to do a variation to the proposed plan through the process, through the streamlined process, and that will look at what the zone provisions are, it'll look at the qualifying matters, right? Look at the qualifying matters, look at where they land, consider whether towns, for instance, like with Malcolm and Prebbleton, both in less than 5,000 people are included or excluded.
Yeah.
And likewise, where large lot zones are also able to be excluded, and there's a consideration of what does large lot mean in a Selwyn context, where probably sort of a third of the existing Prebbleton zone is large lot, half of with Malcolm is large lot. So council, through the proposed plan, is going to do a variation to that to look at to introduce the medium zone that aligns with the enabling act, and to get around what the qualifying matters are. And then there's a question of with this change to an alternate plan. Clause 34 talks about plan changes that are in process. Council doing a variation to those, and so this issue that council wrestling with, still getting advice on, is whether that means you have to issue your decision, they then kind of hold that, do a variation to it at the same time they do the variation to the proposed plan, and it kind of runs through a parallel with that, or whether actually you can issue your decision if there are no appeals, it becomes operative, and then that simply gets rolled into the variation to the proposed plan, covering the rest of the rest of the years.
Is council intending to deal with the operative plan and the proposed plan in sort of parallel process,
Well, I think you do, and that's what their initial thinking was that they focus on the proposed plan, that then becomes operative and the operative plan falls away, and you don't worry about that at all. I think because there are all these product plan changes to the proposed plan that are sort of mid-train and being incorporated, that they are now thinking like you will have to do a change to the operative plan as well, albeit at the same time, and albeit that operative plan having gone through the process then will fall away, you know, within a number of months. So it is really challenging with these sort of amendment acts that sort of are done, you know, quite quickly into the process and have implications. And where the cell planning process is probably as complex as any council is going to find for this amendment act. So it is in train. I think the key message for you is that council's position is that you just make a decision on the plan before you give the decision to council. They will then deal with the implications of that in terms of the amendment act process.
It's useful the word variation, isn't it? Given the timing and everything, and not variation or change. But if it says you must introduce variations. The only other way to do it is probably to notify a decision and for the technical appeal, and it can't be made off.
Yeah.
Just thinking.
So obviously the bill only became an act before Christmas. We're only kind of a couple of weeks into the new year, so I think everyone is still working their way through the implications of it. So
yes, right. I understand your advice to me, and that makes sense, and you deal with the problem. Yeah.
Because I should also mention that in terms of the commentary on the amendment act and the implications of the head of capacity assessment. So again, something everyone's going to have to get their head around. I think it's really important to build on between enablement and whether the market chooses to take up that enablement. And that's especially the case in Selwyn, where, as I just said before, Northern Z for a long time has, if you like, enabled medium density. It's the requirement to achieve a minimum of usually was 10 houses per hectare, that sort of edged up to 12 houses per hectare, but that's a minimum. So, and those minimums are in there, and they're in the RPS because back, we'll go back to 2007, all the plans, or most of the plans in the cell were very, very low density outcomes because that was more the market was at the time. And a lot of these just improvements was quite a lot, very, you know, thousands per litre plus sections. So when the UDS came working its way through, the view was that we don't want super low density suburbia, we want to increase the yields to sort of reduce the amount of fuel necessary to acquire the same amount of growth. So the RPS keeps requirement that every producer has to achieve a minimum of 10 houses per hectare in selling. So that rule is in there, and subdivision consents have to demonstrate that they can achieve that minimum. So that's all about kind of ensuring that the market delivers at least a certain amount of yield. But there's never been much of an issue that developers want to provide more yield than that. And so they've always had this ability to do medium density through discretionary consent. And developers have to a certain extent taken up that opportunity in order to achieve a 10 houses per hectare minimum.
Yeah.
So they kind of trade off having some large lots in certain locations versus a small lot elsewhere. Yeah. So, but even then, the medium density properties that we see in Selwyn are not what you think of the medium density in a Wellington or Auckland context, of sort of terraces or three-story apartments. They're very much still generally standalone houses on 400 square metre-ish sections. So it's a typical Selwyn outcome just shrunk of it rather than a change in topology to terraces or units. You do get the odd semi-detached where the two garages join up, but generally speaking, it's still rough medium density in Selwyn means 400 to 450 square metre sections, typically with a standalone house, just a smaller house on it. So I guess all I'm saying is that the opportunity to do denser and to do townhouses into a multi-story or two-story at least in Selwyn has been there for a decade or so. But developers haven't taken up that opportunity purely because the market isn't really there. It's not why people come to Selwyn. So even if we do see the medium density the Act requires council to enable much higher density. It will be really interesting to see what the market does with that opportunity. And I'm cautious that we'll see high uptake. I think it will still look much like the current style houses to get outcomes. But that's all speculative. We don't know that, and that's what makes it quite.
It switches the market from the professional developer to the mum and dad's front yard market. And that is the problem, is that I think people will see some bright lights because of the prices.
Yeah, and again, I think they would sound on conflict. I agree with you absolutely. I think it's certainly the case in Christchurch City where you've got someone going back sort of 10, 20, 30 years. In Selwyn, once you exclude the large lot zones, and they got filled with development, because the vast majority of Selwyn in the Plains Township has developed over the last 10 to 12 years. They've all been done on that achievements of 10 houses per hectare plus. So generally speaking, to get to 10 houses per hectare, typically they're around sort of 600 square metre sections, ballpark terms, with typically a 200 square metre plus house up right in the middle of it. So the actual practical ability to sort of chop up the backyard is quite different to sort of where I live, Beckenham and Christchurch, where it's more 800 square metre sections with a 120 square metre bungalow on the front. And suddenly you do actually have opportunities to sort of power up the backyard or do something quite different. But because the vast majority of the urban area is new housing, so it's got a lot of capital value that doesn't stack up to demolish it to, demolish one brand new house to replace it with two or three. Plus the layout of the sections means that it's quite hard to subdivide who the backyards off. There will be some sections where you can do it, and some of the older parts will also. So there certainly will be a bit of ad hoc capacity release. But I think in practice, the ability to take up the opportunities are going to be reasonably limited in the existing recently developed parts in the Plains Township. This is my feel.
I get your point clearly that there's a big difference between that new development, still relatively fresh, and what you might say is older suburbs of Christchurch.
So that just gives some Selwyn Council going to work through into what the variation looks like, and then it's going to be quite challenging doing the next housing capacity assessment, where you've got a whole lot of capacity theoretically enabled, and we're going to have to be quite careful about what the capacity assessment has to be sort of enabled by the plan, but also sort of practical, or be some sort of wording around sort of realistic. And so it's going to be quite challenging, I think, to work at what here. But that's all for the future. I think for now, in conclusion, I'll finish my paragraph 26 my last paragraph. In a nutshell, the site has long been identified as being suitable for a change from rural to a low-density residential zone as a means to create an appropriate edge-of-town boundary. The park acquisition has materially, in my view, shifted the location of the edge-of-town boundary. It's therefore appropriate to reconsider or respond, in the words of the Ndrs, to how best to infill the resolve gap, with the primary options being a very low-density rural residential outcome or a more suburban outcome with a mix of typologies. In that regard, I do take issue with Mr. Langland saying this should be declined on the level that doesn't provide a range of typologies. His recommended outcome is rural residential, which is uniformly 5,000 square metre sections with really big houses on. So, in my view, the living Z outcome actually provides a much greater range of typologies on into sort of smaller houses than the alternative being the rural residential outcome. The shift to increased yield with a range of typologies in an appropriate location, in my view, aligns comfortably with the need to be responsive regarding the housing supply outcome sought from the NPQD. So it ticks the merit-based boxes of the NPQD. The site, likewise, in my view, sits comfortably within the wider urban growth policy direction provided by the RPS and the operative district plan, apart obviously from the directive urban edge policies which preceded the NPQD and appear to be robust review. And therefore, I recommend that PC73 should be approved. And then just finally, in terms of if you were wanting to approve living Z densities, in terms of the further amendments further matters to change your minds, I guess, in terms of whether you think there is an amendment necessary. My list is whether the narrative includes reference to the need for safety upgrades on Christchurch Road, whether the narrative include, if the Drillings block is included, on actual regardless of if you're included or not, the need for narrative around storm disposal onto the Drillings land. The Ministry of Education need for a narrative to include discussion, and then to the MOE, because whether additional rules need to be included. In my view, they don't. And as you noted, youth schools are designated, and even if education, you know, is a result of community activity in sort of the living zone framework, new schools going into the little greenfield sites have never had a trouble being designated for selling, you know, because there aren't any neighbours. It's a greenfield situation. There's, you know, half a dozen new primary schools have gone into greenfield situations and roles in the last decade in greenfield situations, and they've never, as far as I'm aware, had difficulty gaining consent being designated for that purpose. So I do agree with the ministry and obviously the applicant agrees as well of the need for the ODP narrative to open the door to have that conversation at time subdivision as to whether a school site is needed or not. And there respects that overt trigger to having the conversation, I think is what Mr. Collins is looking for in terms of trust road safety upgrades. And actually what I think the journalists will also be seeking as well. Simply saying, look, there's a question mark over outboard or over the detailed design. We just want to make sure that as part of the subdivision process, it's not lost in the mix. It's lost in the full kind of in the gap between this plan change hearing and when a different consent plan is looking at a subdivision consent. So I'm on track. So trust road safety, Ministry of Education school board conversation with the journals, and then rail trail linkages or cycleway linkages. And again, for me, it's about creating a cycleway network. So whether the rail trail ultimately relocates in its entirety into the middle of the plan change and then through the middle of the path, or whether it stays on the purchase road edge, doesn't materially matter. We want good solid routes both through the middle and along the edge, and with those two routes connected along Trusses Road.
Yeah.
So the key outcome I think Mr. Nichols is looking for is overt recognition that, especially along the Trusses Road frontage, that there is a shared cycleway link between, you know, Beach Road, rail trail, back into the mid block through some way cycleway through, and same again on Beach Road.
Yeah.
And
just on the education thing, I decided not to extend the conversation much further, but I'm certainly expressing the view that I'm not supportive of the need for additional schools. And state integrated schools can be designated anyway for state schools. So I'm happy to communicate my position on that.
So they are the board for like it.
Yes. There's a few other things that Mr. Collins, I think, tweaks to answer the question. I'm not seeing any of those as being particularly controversial. I sort of can signal, I sort of agree with the nature of the shopping list, and I'm sure will come back with and reply something that reflects those. I think in terms of finalising the ODP process, I might even consider whether I want to issue a minute in relation to the Drinners decision part of it, because that might help then tidy up other stuff. I'm just signaling that's a thought that's only just come to my head, and just in terms of almost mechanics. It wouldn't be a decision, but it would be a minute indicating where I'm going with that and enabling some tidy up matters possible to be addressed. So just depends where I do get on. So I think that might be a way for me to see.
I think it could even be a minute simply saying, I think that two ODP options, one that includes the additional forestry, one that doesn't, and then you don't have to take any minute, you have to signal that you want to, don't signal a substantive.
You want a good idea, Mr. Craig. That would be a very helpful approach. Thank you.
Yes, just on that point, sir. My legal submissions haven't introduced scope because the applicant has taken quite a neutral stance in relation to the Drillings view, there are some very real issues in terms of the evidential information that needs to be provided for the journals, which is just currently not available. And I think the updates that would be required to both the ODP and the narrative would require that level of expert input to consider those issues. And I think the level of investment that's been undertaken by the Trice's Road rezoning group, not wanting to sound like I'm whining, but it is reasonably unfair to them. They have gone through a significant. Yes. And I guess the last point on that is just in relation to the more technical design. Stormwater in particular is something that we're going to look that hasn't been assessed, hasn't been factored into the sizing. And I think in Mr. Drinnan's own submission, he said that there would be a need for some sort of holding area within his land anyway before there was a discharge. So that's just another matter that needs to be considered.
Yes, there was an outstanding stormwater.
Yes. I'll leave that with you. I guess one final point on that is the fact that there is a submission lodged by the Drinnans on the proposed district plan, which is seeking residential rezoning for that site. So there is still a pathway available.
This morning, thank you. And it was on my list of questions. I must have missed it somehow. So there is a submission.
Yeah.
On the proposed plan.
And my understanding is that Mr. Fletcher has indicated that his clients currently haven't confirmed whether or not they intend to put forward the evidential documentation to support that submission. So I think that will restore to me.
Right.
It's an important one, so I think you can do that as well. So you direct, if you're concerned about scope, then you do have, there is that ability for the ultimate trip reference block to be looked at afresh through the planning. You also variations notwithstanding.
Yeah. Okay. All right.
But otherwise, very, very happy with your approach in terms of that.
Right. Good. Okay. I'm sure I'll start trying to be able to think of all sorts of things that I should ask, but that is usual with these things. But I think that's been a very good process so far. So thank you very much to everybody. I don't think I have any other questions. Thank you, Mr. Freeze, for kind of wrapping that up. I think that's helpful from council's perspective. I think I can adjourn the hearing. Now, in terms of time, probably the matter is written reply. I take it you would want to go down that track. I kind of always put it up as an option with a sort of implied preference from a commissioner's point of view. And change is not quite got the same statutory complete hearing deadline like the resource consent. So, how long would you like?
Look, I'm quite keen on behalf of our clients to have this wrapped up as soon as possible. I think Big Friday after so next Friday would be appropriate to stop the refining. That would give us the rest of this week and start next week and next to facilitate the amendments to the open narrative that are required.
No.
Friday's the 11th.
My 40th wedding anniversary on my 10-year day, so that one up too much. 11th of February, okay, that's done deal. 11th of February, reply. At that point, I consider the reply, see if there are any other matters that I've thought of or rise out of it that need to be addressed, which hopefully would be by way of written communication. And I mean, sometimes, in some cases in a reply, you do need to actually reconvene the hearing. I don't think that's likely to be the case where we stand with this one, so I'm not anticipating needing to reconvene the hearing, but I will then formally close the hearing and communicate to the parties. Then I have to knock it down and write a recommendation for. So, thank you very much, very interesting. There are a lot of moving parts, but very good. Thank you. We are now adjourned.
Thank you very much.